and have an order issued directing his immediate release from detention, docketed as GR number 251693, entitled Jody C. Salas, ex-rel person deprived of liberty, Rodolfo C. Salas, as petitioner, versus Honorable Medina-Bunyi Medina, presiding judge of the Regional Trial Court of the City of Manila, Branch 32, Jail Chief Inspector Lloyd Gonzaga, Warden of the Manila City Jail Annex, and all those taking orders, instructions, and directions from him as respondents.
Counsels, please enter your appearances, starting with the petitioner.
Appearances.
Counsels for the respondents, please enter your appearances.
Good morning, Your Honors. We represent the respondents in this case, Your Honors. I'm Solicitor General Jose Calida, Your Honor.
Good morning, Your Honors. Assistant Solicitor General Gilbert U. Medrano, Your Honors.
Good morning, Your Honors. Assistant Solicitor General Hermes Ocampo.
Good morning, Your Honors. Assistant Solicitor General Raymond Ayricudon.
A pleasant morning, Your Honors. Assistant Solicitor General Anglita Villanueva Miranda.
Thank you. Please be seated. Counsel for the petitioner, kindly take the podium. Counsel for the petitioner, please take the podium. Since this is a habeas corpus case, may I know if your client is here?
We would like to inform the court, Your Honor, that Mr. Rudy Salas, the person for whom this petition was filed, is present in court
Your
today.
client in this case is the son of...
The son and, of course, Your Honor, the detainee. The
Yes.
son is Jody Salas. He is present.
Can the son of Mr. Salas please stand up? And can Mr. Rodolfo Salas also stand up? Does your client, the son of Mr. Salas, confirm that this is the person of Mr. Rodolfo Salas?
He confirms, Your Honor.
And the person now wearing yellow, can you state your name, please, for the record? It's Rodolfo B. Salas. Thank you to both of you. Mr. Counsel, apart from the alleged violations of constitutional rights that you have pleaded in your petition for habeas corpus, did you have access to your clients prior to this case?
We have access, Your Honor.
Are there any other violations of constitutional rights other than those that you have pleaded in your petition for habeas corpus?
None, Your Honor.
None. The detainee may sit down. Counsels are given 20 minutes each to present their oral arguments. After the petitioner, the Solicitor General, on behalf of the respondents, will also present his 20 minutes oral arguments. Thereafter, the court will interpellate. Okay. Counsel for petitioner, you may proceed.
Good morning, Your Honors. Your Honors, Mr. Chairperson, and the members of the Third Division, may it please this Honorable Court. In its advisory, the Court assigned 2 issues for the parties to address. With due respect, Your Honors, there is only just one issue, and that is Mr. Rodolfo Salas lawfully detained? It is our respectful submission, Your Honors, that it is not. Perforce, the privilege of the writ of habeas corpus must be granted to Mr. Rodolfo Salas. As a preliminary matter, Your Honors, Mr. Salas wishes to reiterate his urgent application for a TRO as well as his alternative application for bail. The trial court, in this case, Your Honor, has scheduled the arraignment on March 17, 2020, surprisingly from 8:30 in the morning till 4:30 in the afternoon, with a warning to Mr. Salas that the arraignment will not be reset. Should he be arraigned, Mr. Salas will be forced to undergo trial for what we call a patently unconstitutional charges. For this reason, the application for a TRO becomes, Your Honors, very urgent. On behalf of Mr. Salas, we respectfully pray for the immediate issuance of the TRO while the court resolves this petition. As a second additional point, Your Honor, pending resolution of the habeas corpus petition before Your Honors, Mr. Salas requests for temporary liberty on reasonable bail following the same treatment of this honorable court to Ocampo and his other co-accused. Addressing the main issue presented to this court, it is respectfully submitted that Mr. Salas's situation is sui generis. And for this reason, this court must consider looking beyond a reflexive reaction to rely simply on the text of Rule 102, particularly Section 4 thereof, and to consider the unique circumstances of his captivity to determine the appropriate remedy. This petition, Your Honors, is anchored on the application of two controlling doctrines of this court. These are People versus Hernandez and Gumabon versus Director of Prisons, which, despite their vintage, remain evergreen. Hernandez tells us that when a person is charged with rebellion, all common crimes committed in furtherance or in connection therewith are necessarily absorbed in rebellion charge and cannot be complex with rebellion, nor can they be charged separately. Hernandez by now has become canonical as to be beyond serious dispute or challenge. Mr. Salas was charged with rebellion and convicted in the year 1991, to be specific, April 1991. Through a plea bargain, he voluntarily entered into, with full concurrence, Your Honors, of the state, represented then by prosecutors of the Department of Justice. That plea bargain, quote unquote, was approved, resulting in a judgment that has become final, and therefore it is the law of the case insofar as Mr. Salas or the parties in that case is concerned. Mr. Salas fully served the sentence in that case of 6 years and 1 day under the plea bargain, and thus the judgment constitutes the first jeopardy. Under the Constitution, therefore, it now fulfills that first jeopardy under the elements of double jeopardy. The sui generis nature of Mr. Salas' situation arises from a specific stipulation, Your Honors, contained in the judgment of the trial court approving, quote unquote, the plea bargain agreement. That stipulation reads, and I would like to quote, open quotes, open parenthesis 2-E, close parenthesis, that both accused will be covered by the mantle of protection of the Hernandez-Enrile political offense doctrine against being charged and protected for any common crime allegedly committed in furtherance of rebellion or subversion. Close quotes. That stipulation, Your Honors, is simply a reaffirmation and reiteration that Hernandez applies to absorb any and all crimes committed in furtherance or in connection with rebellion. However, its effects, the judgment in the lower court, its effects extend the reach of the trial court's decision in 1991. It extends to today and to the case against him now. The judgment of the trial court, which contains that stipulation, expressly reaffirms the protection of Hernandez to all cases that could have been filed against Rodolfo Salas at that time, and also to all other cases that may be discovered but could not have been filed at that time. Which brings us, Your Honors, to today. Mr. Salas is now being charged with murder, allegedly committed in connection with a rebellion for which he was already convicted in 1991. Under Hernandez, therefore, the charges should have been absorbed had they been filed at the time of his trial for rebellion. Under the final judgment of the trial court convicting him for rebellion, then these alleged murders are barred as they are now absorbed in the rebellion conviction. To make it plain, Your Honors, Hernandez characterizes any and all related felonies and crimes as elements or acts inherent in the felony of rebellion. For this reason, any charge or charges for these related felonies and crimes outside a charge of rebellion would be a prosecution for the same offense and the same act or the same crime, which, under the Constitution, clearly, Your Honors, constitutes double jeopardy. In Gumabon versus Director of Prisons, this court ruled that when a violation of a constitutional right is shown, the court that issued the order or rendered a judgment in violation of such right is deemed ousted of its jurisdiction, and its orders and judgments are therefore void. Mr. Salas is protected by the Constitution against double jeopardy. The application of Hernandez and the final judgment for rebellion further underscores this protection. The present information in the lower court, Your Honor, charging Mr. Salas for murders allegedly committed in 1985, and the warrants issued under the information, therefore places Mr. Salas in double jeopardy. To emphasize, Mr. Salas was convicted of rebellion for acts committed as its leader between 1970 and 1986. The offense for which he is being charged in the lower court now was allegedly committed in 1985. As a factual matter, therefore, the alleged murders currently charged are absorbed. As a legal matter, therefore, the alleged murders currently charged are barred. As a constitutional matter, therefore, the alleged murders constitute double jeopardy. In People versus Geronimo, this honorable court ruled that the commission of serious violence upon civilians is a necessary part of rebellion. Again, this court, in People versus Agarin, ruled that the execution of civilians suspected of being spies and government informants is not murder, but simple rebellion. The mere filing of an information for charges covered by now the final judgment for rebellion therefore places Mr. Rodolfo Salas in double jeopardy. For this reason, Your Honors, Gumabon applies. The patent violation of his constitutional right to be protected against double jeopardy therefore ousts the trial court of its jurisdiction. It voids the information insofar as he is concerned alone, and all processes including the warrants and the commitment orders as against Mr. Salas. We would like to stress the violation of double jeopardy is solely for Mr. Salas in the case before the lower court. It does not in any way affect the other accused in that case. Traversing the return, Your Honors, it is clear that Rule 102, Section 4 does not apply to the case of Mr. Salas alone. The provision is contingent on a court with jurisdiction. The trial court seeking to try Mr. Salas for these murders is not that court. Further traversing the return, which cites the ruling of this honorable court in Ocampo versus Abando, which covers actually the other accused in the lower court's case. In response to the doctrine of People versus Hernandez, it is respectfully submitted that in the case of Mr. Salas, Ocampo versus Abando does not apply. Why? Two things, Your Honor. First, Mr. Salas, unlike the other co-accused in that case, has already been tried, convicted, and has fully served his sentence for rebellion. In Ocampo, the rebellion case was being tried simultaneously with the case for murder. Here, Mr. Salas has already pleaded guilty to the offense of rebellion for acts committed between 1970 and 1986. Second, Mr. Salas, unlike his co-accused Ocampo et al., has no burden, Your Honors, to demonstrate a political motive. The 1986 amended information for rebellion and the 2007 information for murder, documents which the state itself prepared, readily show that the acts being charged were committed in the same time frame, in his same capacity, and for the same offense. Thus again, double jeopardy. Applying Hernandez as expressly applied to Mr. Salas through the trial court's final judgment for rebellion, and Gumabon, which ousts the respondent trial court of jurisdiction, the remedy of habeas corpus remains for Mr. Salas to be the only viable and effective remedy. This, notwithstanding the ruling of this honorable court in Ilagan versus Ponce and Rile, which, because of the unique circumstances in this case, does not apply. For Mr. Salas, habeas corpus is the only proper remedy because it is the only remedy that can immediately relieve him of the state's unconstitutional deprivation of his liberty. Any other remedy, Your Honors, will cause him to remain in jail more than he should. Traversing the return further, Mr. Salas cannot be required to invoke remedies before the trial court, as this would render nugatory the peremptory protection of guarantee against double jeopardy. For this reason, there is no violation of the principle of hierarchy of courts. For one, there are no serious factual matters insofar as Mr. Salas is concerned. Further, this court, under Article 8, Section 5 of the Constitution, is enshrined protector of fundamental rights. And finally, this court retains concurrent jurisdiction over petitions of habeas corpus. Requiring Mr. Salas, Your Honors, to invoke remedies in the trial court against a patently void charge to free him from consequently void detention would be to force him to give up some of his rights in order to invoke others. For instance, to require Mr. Salas to plead his previous conviction under Rule 117 a motion to quash. To plead double jeopardy would require him to give up his right to due process and speedy trial, as it would require him to participate to Hernandez and Gumabon as void. Further traversing the return, forcing Mr. Salas to prove that he had political motive means he has to go to trial. This is precisely, Your Honors, the evil that the constitutional right against double jeopardy seeks to prevent. What the state, through the Solicitor General, suggests in the return is an unacceptable situation that this court must shield Mr. Salas from. This court can do by granting Mr. Salas the privilege of the writ of habeas corpus, which, as demonstrated, remains viable and is under the circumstances urgent. Your Honors, Mr. Salas does not ask this court for new doctrine. Mr. Salas does not ask this court for a new exception. Mr. Salas is just asking this honorable court that present doctrine and the exceptions raised by this court be equally applied to him given his circumstances. Thank you, Your Honors, and may it please the honorable court.
Thank you, counsel, for the petitioner. Can we now have the Honorable Solicitor General for the respondents for his opening arguments? The respondents are also given a like period of 20 minutes.
May it please the honorable court. The petitioner claims that his father, Rodolfo, has been forcibly nabbed by the Philippine government through its police in violation of his constitutional rights to due process and the prohibition against double jeopardy. He is gravely mistaken. Contrary to what petitioner wants this honorable court to believe, the present case is not one of government oppression. Rodolfo Salas, alias Commander Bilog, was lawfully arrested because of the crimes, specifically, 15 murders he committed. These 15 murders were discovered from a mass grave site in Inopacan, Leyte, as can be seen in the screen, Your Honors, and are among these 67 severely deteriorated skeletal remains exhumed 3 decades after the brutal torture and murder. They are more than skulls and bones. They are lives unfulfilled, persons who could be here today had it not been for the heinous crimes committed against them. These bones were once mothers, fathers, daughters, and sons, long missed by their families. The case before this honorable court is a story of giving closure to the families of murder victims, deprived of justice, while the accused hid under the table of a trial court judgment that does not cover the crimes he is presently accused of. Your Honors, the facts and arguments we present today will fill in the noticeable blanks of petitioner's story and prove that Rodolfo's present detention is not illegal. At the outset, petitioner's immediate resort to this honorable court through the extraordinary remedy of a petition for habeas corpus is not only improper, it also disregards the court processes and remedies available to him before the trial court, for which he is presently charged with 15 counts of murder. In the words of the erudite Justice Mario Victor Leonen in Osorio versus Navarra, and I quote, "A writ of habeas corpus may no longer be issued if the person allegedly deprived of liberty is restrained under a lawful process or order of the court. The restraint then has become legal. Therefore, the remedy of habeas corpus is rendered moot and academic. If an accused is confined under a lawful process or order of the court, the proper remedy is to pursue the orderly course of trial and exhaust the usual remedies. This ordinary remedy is to file a motion to quash the information or the warrant of arrest based on one or more of the grounds enumerated in Rule 117, Section 3 of the Rules of Court, unquote. Let me expound, Your Honors. The privilege of the writ of habeas corpus should not be granted because Rodolfo's arrest and subsequent detention are by virtue of a legal process. Your Honors, under Section 1, Rule 102 of the Rules of Court, the writ of habeas corpus extends to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. Thus, the remedy has one objective: to inquire into the cause of detention of a person. If found illegal, the court orders the release of the detainee. If lawful, then the habeas corpus proceedings terminate. The privilege of the writ shall not issue when a person allegedly deprived of liberty is in the custody of an officer on the strength of an order or process issued by a court. The restraint has become legal. Indeed, the Honorable Court has consistently held that the privilege of the writ of habeas corpus should not be allowed after the party sought to be released has already been charged before any court. Petitioner admits that informations for 15 counts of murder were already filed against Rodolfo and that the latter was arrested by the PNP on February 18, 2020 by virtue of the warrant of arrest issued by the public respondent. Hence, his detention at the Manila City Jail is lawful. Moreover, petitioner even attached as Annex D of his petition the commitment order dated February 20, 2020, issued by the public respondent, which mentions, and I quote, criminal case numbers 08-262163, open parenthesis, formerly H-1581, close parenthesis, and 14-306533 to 14-306546, 14 counts for murder. With this admission of a commitment order, Section 13, Rule 102 of the Rules of Court is clear, and I quote, if it appears that the prisoner is in custody under warrant of commitment in pursuance of law, the return should be considered prima facie evidence of the cause of restraint. Considering that Rodolfo's detention is by virtue of the lawful public authority, the instant return is considered prima facie evidence of the validity of the restraint, and the petitioner has the burden of proof to show that the restraint is illegal. The petitioner availed of the wrong remedy. Your Honors, given that Rodolfo is confined under a lawful order, the proper remedy is to pursue the orderly course of the criminal proceedings and exhaust the usual remedies. Instead of pursuing this, however, petitioner chose to ignore the ordinary remedies available to Rodolfo and immediately filed a petition for habeas corpus contrary to established jurisprudence. As the Honorable Court has declared, habeas corpus cannot be used as a substitute for another and more proper remedy. It is neither in the nature of a writ of error nor intended as substitute for the trial court's function. It cannot take the place of appeal, certiorari, or writ of error. It cannot be used to investigate and consider questions of error that might be raised relating to procedure or on the merits. More importantly, it should not be granted in advance of trial in the absence of exceptional circumstances. Here, the ordinary remedy is to file a motion to quash the informations. There is also nothing stopping Rodolfo from asking for a reinvestigation, especially since he has not yet been arraigned. It is premature for this honorable court to hold that the constitutional prohibition against double jeopardy has been violated. Petitioner raises factual issues in invoking the remedy of habeas corpus. These factual issues still need to be threshed out by the trial court and cannot be determined in a habeas corpus proceeding, which is summary in nature. To enumerate, petitioner argues that, number one, Rodolfo's constitutional right to due process was violated because he was allegedly not afforded the opportunity to participate during the preliminary investigation of the complaints for murder. And number two, the current prosecution of the murder charges against him is in violation of his constitutional right against double jeopardy. Petitioner likewise asks the Honorable Court to prevent the RTC Manila, where the informations for murder against Rodolfo have been filed, from continuing to perform its duty to arraign him and proceed with the trial on the strength of a previous plea bargaining agreement that he had previously proposed and consented to and approved by the RTC Hilongos Leyte. These arguments all present factual issues outside of the province of the habeas corpus proceeding. Petitioner primarily invokes the political offense doctrine laid in People versus Hernandez. The doctrine states that certain crimes such as murder are already absorbed by the charge of rebellion when committed as necessary means and in connection with the furtherance of rebellion. Yet, the Honorable Court has already declared in Ocampo versus Honorable Abando, a case with the same factual antecedents as this present case, that in instances where the political offense doctrine is invoked, it is crucial to determine the motive, whether the act of killing was done in furtherance of a political end, and for the political motive of the act to be conclusively demonstrated. Motive is adduced during a trial, where both parties are given opportunity to present evidence supporting their position. Thus, the political offense doctrine, when asserted as a defense, must first be determined by a trial court. The trial court must determine whether the crime to be constituent of rebellion was done in furtherance of a political end, and for the political motive of the act to be conclusively demonstrated. I agree with the marvelous observation of our Honorable Justice Leonen in his separate concurring opinion in the said case, and I quote, "However, indignities masquerading as dissent or even brought about by misguided assessments of what is pragmatic do not deserve any legal protection. Such acts cease to be political. These are simply inhuman. Acts which debase humanity, even by the most organized and ardent dissenters, do not even deserve the label of rebellion." Accordingly, in the same case, the court remanded the case to the trial court for the determination of factual issues. There is no reason for this honorable court to rule differently in the present case. Here, the RTC Hilongos Leyte decision that approved Rodolfo's plea bargaining agreement did not enumerate the constituent crimes Rodolfo committed in furtherance of rebellion, but merely quoted the amended information charged against him. This amended information enumerated the acts Rodolfo committed in furtherance of rebellion and did not, and I repeat, did not include the 15 counts of murder committed by Rodolfo for which he is presently charged. Absent any factual finding from the said decision, the present murder charges against Rodolfo cannot be automatically considered as to have been absorbed in the crime of rebellion. Here, petitioner merely made bare allegations that the present murder charges against Rodolfo have already been absorbed by the earlier crime of rebellion. As previously stated, the decision convicting Rodolfo of rebellion did not state that it included the 15 counts of murder committed by him. Neither did Rodolfo present any evidence before the trial court supporting his assertion that the present murder charges are part of the crime of rebellion he was previously convicted of. Petitioner's immediate filing of the present petition before this honorable court without availing of the remedies available to him before the trial court is a procedural shortcut that should not be countenanced. Lastly, the mass graves were only discovered on August 26, 2006, or after Rodolfo was convicted of rebellion. To be sure, the murder of the numerous victims was not among those admitted by Rodolfo in the compromise agreement entered between him and the handling public prosecutor then. It cannot therefore, Your Honors, be disclaimed that the prosecution or the private offended parties have not consented to the inclusion of these murders in the plea bargaining in violation of the strict provision of the law. Aside from its impropriety and utter lack of basis, the present petition suffers from fatal defects that should lead to its outright dismissal. The petitioner violated the doctrine of hierarchy of courts. The jurisdiction of the Honorable Court to issue writs of habeas corpus is not exclusive, but concurrent with the regional trial courts and the Court of Appeals. However, such concurrence in jurisdiction does not give the petitioners unbridled freedom of choice of court forum. Here, petitioner presents no compelling reason to justify direct resort before this honorable court. In this regard of the Court of Appeals jurisdiction and in violation of the policy of the hierarchy of courts. As earlier explained, Rodolfo's argument that his rights to due process and protection against double jeopardy would be properly addressed by the trial court. Given the impropriety of the remedy and the lack of basis for which it should be granted, it goes without saying that the present petition should be dismissed. Your Honors, the 15 counts of murder charged against Rodolfo took decades before it was discovered. Subsequently, it took more than a decade before Rodolfo could be presented to the court for the informations filed against him. Rodolfo is not under detention for capricious reasons, but to be tried for the murder of the 15 victims. All we ask, Your Honors, is for this honorable court to allow the regional trial court in Manila to continue hearing the criminal cases filed against Rodolfo. There, his defense team can avail of the appropriate remedies to argue his case, and if need be, avail of the appeals processes also available to them. All we ask, Your Honors, is for this honorable court to allow the wheels of justice to run its course. Thank you, Your Honors.
Thank you to the Honorable Solicitor General. The court, through the justices present of the third division, will now proceed with interpellations. Our agreement is that each justice may call upon the petitioner or the respondent in the order that he or she may prefer. We will now proceed with the interpellation. Justice Garland will proceed.
Thank you, Mr. Chairman. Can I ask counsel for the petitioner, Attorney Arno Sagadian, take the restroom, please?
Yes, Your Honor.
First of all, Attorney Sanidad, I like your prefatory statement as stated in your petition. How many times must a man look up before it can see the sky, as quoted in the song Blowing in the Wind by Bob Dylan? That's my favorite song next to Let It Be by John Lennon. Okay. Now, let me start with your claim that the instant case is sui generis and hence was properly referred to this court through the writ of habeas corpus. And you even cited the case of the landmark case of People versus Hernandez. Okay. Who determines if a crime is considered part of a political offense?
Pardon, Your Honor. Again, please.
Who determines if a crime is considered part of a political offense?
Well, the prosecution would be the one to determine, Your Honor, based on the facts presented in the resolution and information they file.
Okay. So it's not the court who determines it.
No, Your Honor, unless there is a final question of the constitutionality of that information or resolution, Your
So
Honor.
even this court cannot determine it.
It
Is
can
that what-
determine now, Your Honor, based on the information and resolution upon which the charge is based in the lower court. May I elaborate, Your Honor?
Yes, please.
The position here of the state is that Rudy Salas should have availed of remedies in the lower court, such as a motion to quash or a motion for preliminary investigation, since he was not accorded or afforded that remedy. Your Honors, to ask Rudy Salas to go through those remedies below would result in his continuous detention until this very court rules on the issue of double jeopardy. I'll give you an example, Your Honor. In the case, for example, of Ivler versus San Pedro, the issue there was a habeas corpus. The issue below was whether or not the motion to quash on a ground of double jeopardy filed by Ivler in the lower court was valid or not. The lower court, through Judge San Pedro, ruled that against the existence of double jeopardy. What happened? It took 6 years. It came up to this court, and only this court ruled that there is indeed double jeopardy. Again, in the case of People versus Yora, it took, I think, another 4 years, the same instance. A motion to quash was filed in the lower court. The issue was double jeopardy. The person had to come up to the court, and it was only this court that ruled that there is indeed double jeopardy. To ask Rudy Salas to undertake that normal procedure under the specific circumstances he finds himself, Your Honor, because he is charged for 15 counts of murder, which is non-bailable. In the cases of Ivler and Yora, these were small common crimes for which they had the opportunity to be out scot-free while the petition was being ruled upon this court. If the accused should go through the normal procedure in the lower court, it would mean that he would be detained until the issue will be brought up to this court finally, and this court will finally decide as between the prosecution or the defense whether there is double jeopardy.
So that's the reason why you did not avail of filing a motion to quash or for a motion for investigation before the lower court.
That is one of the reasons, Your Honor.
Okay.
The other reason is there is a violation of a constitutional right of double jeopardy. And that gives us the opportunity that the remedy be brought directly before this court, because this court is the final arbiter of constitutional issues. Again, I'd like to go back. Let us operationalize the situation if we file a motion to quash based on double jeopardy before the trial court. One scenario, Judge Bunyi would have granted our motion to quash. Do you think that would put an end, realistically, to the charge against Rodolfo Salas? I am certain, Your Honor. The prosecution would have appealed it up to this court, up to the Court of Appeals, or up to this court. How many years will that take? While Rodolfo Salas languishes in jail because the charge for which he is being held is a non-bailable offense. Taking the other scenario, Judge Bunyi denies the motion to quash. What are we supposed to do? Naturally, we will have to come up to this honorable court. Again, how long does Rudy Salas have to remain in jail for the issue of whether or not double jeopardy applies to him? Ultimately, at the end of the day, a year, 2 years, 3 years while he is detained, the issue will be here again before this court. That is the reason, Your Honor, we are now before this court. There is a violation of constitutional rights.
Now, let's move on to the procedural matters. Generally, what are the instances when a person may avail of the writ of habeas corpus? Attorney
Well, Your
Senator?
Honor, as a general rule, the writ of habeas corpus is available when there is an illegal detention, Your Honor. And second, by an officer of the state. The second is when freedom of a person is being withheld also by a private person. But here in this instance, it is the state that has denied and continues to deny liberty to my client.
So, am I correct to say that it is a proper remedy to address all kinds of confinement?
Meaning, address all types of confinement? No, Your Honor.
No.
Unless the person there is a strict violation of constitutional rights. Only then and only then, pursuant to Gumabon, pursuant to Celeste, pursuant to Calvan, only then, and other cases, can a habeas corpus case where there is an arrest be brought up before this court because there is a violation of a constitutional right. That is the ruling in Gumabon, and that is the standing doctrine of this country through this court, Your Honor.
Is habeas corpus exempt from the doctrine of hierarchy of courts, Attorney Sanidad?
Your Honor, I would like to say yes, because
Why?
Because, Your Honor, the jurisdiction of this court itself gives it a concurrent jurisdiction over petitions of habeas corpus, and therefore it is the choice of the appellant, or the petitioner rather, where to file it. Under this situation, because of the unique factual circumstances, to have filed it below, as I said earlier, would continue and ultimately find its place before this honorable court.
So, you're saying that it falls under those circumstances.
Yes, Your Honor.
Now, let us... can you define for us? I am referring to Rule 102, which you mentioned earlier, Section 4. Can you read it for us first, Attorney Sanidad?
Section 4. When writ not allowed or discharge authorized, if it appears that the person alleged to be restrained of his liberty is in custody of an officer under process issued by a court or judge, or by virtue of a judgment or order of a court of record, and that court or judge had jurisdiction to issue the process, render judgment, or make the order, the writ shall not be allowed. Or if the jurisdiction appears after the writ is allowed, that the person shall not be discharged by reason of informality or defect in the process, judgment, or order, period. Nor shall anything in this rule be held to authorize the discharge of a person charged with or convicted of an offense in the Philippines, or of a person suffering imprisonment under lawful judgment.
Okay. quoting that provision in the rules, can you define what constitutes a lawful process, Attorney Tanita?
Well, Your Honor, it is presumed that any issuance of a court is a lawful process until questioned. The matter here being presented to you, Your Honor, to the Honorable Court, is the phrase, the key operative phrase in this Section 4 is that the court or judge had jurisdiction to issue the process. That is why gumabon comes into play. Gumabon says, when there is a violation of a constitutional right, jurisdiction of the court is ousted. It is on that basis, Your Honor, that we bring this habeas corpus petition before this Honorable Court.
So if a person is indicted under a lawful process, what are his available remedies under the law?
Oh yes, Your Honor, under the rules on criminal procedure of the year 2000, prior to his arraignment, he can ask for a motion to quash under Rule 117, Section 3, from letter A to letter I, whichever fits his situation. He can ask for a preliminary investigation under Rule 112 or a reinvestigation as the case may be. That may be before trial. Of course, after arraignment, there are certain grounds under Section 3 of Rule 117 that are not deemed waived. And these grounds are that the information that there is double jeopardy, prescription, or service of sentence. And in those instances, Your Honorable Court, this court, has taught us, the bar and the bench, that if a motion to quash is filed on the grounds of double jeopardy, prescription, service of sentence, the judge can go beyond the information. Evidence aliunde may be admitted, as against the ground of the information does not charge an offense as a ground under a motion to quash, which limits the judge and the movant to the four corners of that information. Here, Your Honor, the facts are admitted. This court has said if the facts are admitted, insofar as a motion to quash is concerned, it can be presented. The court can look into it. Why, Your Honor, with more reason, that in a case or a petition for habeas corpus, which in Calvan says it is of protean reach, it goes beyond. It can look into what is behind and why that person is being detained. Why? Because Gumabon says that court is ousted from jurisdiction because there is a claim of a violation of a constitutional right. The claim we raise here is, firstly, double jeopardy. Secondly, speedy trial. Third, due process.
So you now claim that the case is not barred by Rule 102, Section 4.
No, Your Honor. Respectfully, Your Honor, we do not, Your Honor, because of Gumabon, Your Honor,
Okay,
and
because-
succeeding cases.
Now let's move on to double jeopardy. Can we read also Rule 117, Section 7 of the Sanidad?
Rule 1, Section 7 of Rule 117, Your Honor?
Yes.
Section 7. Pardon, Your Honor. I will just get my copy. Rule 117, motion to quash. Section 7, former conviction or acquittal, double jeopardy. When an accused has been convicted or acquitted or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction, upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused has pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or any attempt to commit the same, or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under the following instances. Shall I continue, Your Honor?
No, it's okay, it's okay. Now, Attorney Sanidad, when may a person under criminal prosecution raise the question of double jeopardy? Can it be raised even during preliminary investigation stage?
No, Your Honor.
Why?
Because there is still no second jeopardy. Pursuant to Section 7, and it is clear, the second jeopardy arises only when he is charged for another offense. That charge for another offense should be read to mean the filing of an information. It is only when that information is before the court and he is asked to plead to that information. Thus, double jeopardy attached. Preliminary investigation does not give rise to double jeopardy. Your Honor.
Now, it seems that you are also familiar with the case of Ocampo versus the Honorable Abando. Okay.
I would like to think so, Your Honor.
Okay. Is it on all fours with the instant case?
No, Your Honor. With due respect, Your Honor, it is highly and distinctly different, Your Honor.
What it makes the case at bar different with the case of Obando?
First, Your Honor, Mr. Rudy Salas was convicted in 1991 for offenses allegedly committed in furtherance of rebellion from the year 1970 to 1986. In Ocampo, this honorable court told Ocampo, hey, you cannot invoke the political offense doctrine. Why? Your case in Makati for rebellion is still ongoing. This new case before in Manila, therefore cannot be absorbed in that case in Makati. Besides, the Honorable Justice of the Ponente there said, we dismissed the rebellion case. So there was only one case left, that case before Judge Bunyi. Therefore, double jeopardy, Your Honor, does not apply. Secondly, Your Honor, Ocampo does not have a previous conviction for rebellion. Mr. Salas, on the record, has a previous conviction of rebellion. And that previous conviction of rebellion absorbs the offenses committed for which he is being charged now before Judge Bunyi. Why? Because in terms of time frame, in terms of offense, they should have been part of the original information. To inform this court, Your Honor, I was part of the lawyer, one of the lawyers who negotiated with the Department of Justice for the immunity agreement called a plea bargain agreement. And that is the very what is happening to Rudy Salas, is the very reason we asked that phrase, stipulation, be placed there. That he be protected by the mantle of Hernandez and Enrile for any offense committed, common crime committed in furtherance of rebellion, and then, because it was still an offense, subversion. We had that placed in the anticipation that things like this, Your Honor, would arise, and it has arisen. And we ask this court, therefore, to uphold that final judgment of the lower court and the agreement that is contained in that final judgment, giving rise, therefore, to clearly double jeopardy.
Now, in the Ocampo case, the petitioners were indicted with the crime of rebellion, right?
Yes, no, Your Honor. They were, pardon, Your Honor.
In the Ocampo case,
Yes, Your Honor.
the petitioners in that case were indicted with the crime of rebellion.
No, Your Honor. In the Ocampo case in the lower court, they were charged for the same offense of murder of 15 counts. The very same case now before this court, Your Honor.
Yes, precisely. Did they make any judicial or extrajudicial admission of guilt? For
Ocampo,
the,
Your Honor?
Yes.
No,
for the
I
grand-
don't think so,
okay.
Your Honor. They, in fact, if I remember the decision of this court, it is stated there that Mr. Ocampo denied that he was a member of the Central Committee of the Communist Party of the Philippines or a leader of the CPP, NPA, NDF. It is clearly there, Your Honor. I just cannot just quote the exact words of the court, Your Honor.
Now, in the case of Ocampo, what the court did is to remand it to the lower court to determine the factual basis or factual questions, right? Factual issues.
Essentially, Your Honor, this court said that since there is no ground to cause the dismissal of declaration that the charges filed against Saturo Ocampo were violation of his constitutional rights, therefore they dismissed. It was not a petition for habeas corpus. Therefore, this court said, we dismiss the petition. We remand the case to continue with trial to the lower court. And thus, the trial is continuing. Excuse me, Your Honor. That
And
is
now-
the situation that I...
And now, in this present case, 15 counts of murder,
It is this present case, Your Honor.
yes, were filed against Mr. Rodolfo Salas.
Yes, Your Honor. Yes, Your Honor.
And you want us now to determine the factual issues as to how Mr. Salas allegedly committed the crime, 15 counts of murder?
Your Honor, the basis, whenever, as I said, I mentioned earlier, when one files a motion to quash before the lower court, on those grounds aside from that the information does not state an offense, the court in a motion to quash, the trial court, can look behind the information. Look behind the information insofar as, number one, admissions by the prosecution. Number two, the documents upon which that information is based. If a motion to quash, in a motion to quash, a judge is allowed to go beyond the information, to look at the factual basis of the information, what more? A writ of habeas corpus of which the Supreme Court has said has protean reach. Here, the issue is there a violation of double jeopardy? There are the basic documents that this court should only look into, which is admitted and prepared by the state. Is the information that charged Rudy Salas in 1985 for rebellion, the decision of the court in 1991 convicting him of rebellion, the document that can be based to compare if there is double jeopardy is the information filed against Rudy Salas for 15 counts of murder and the resolution upon which that information is based. Based on these documents, it is clear that the killings of the alleged killings or murder charges were done by the CPP-NPA, allegedly because those persons killed were government spies. And therefore, that necessarily is included by virtue of Hernandez to the crime for which Rodolfo Salas was charged, Your Honor, and convicted in 1991. Again, Your Honor, let's put it this way. Allow me, please. This offense for which he is being charged now in the lower court was allegedly committed in 1985, but was discovered only sometime in 2006. Let us postulate. What if these crimes were discovered in 1984 or 85, immediately after they were committed, and they were not included in the information for which he was charged in Manila? And a separate charge was made for these 15 killings after he was convicted in 1991. Isn't that double jeopardy? Shouldn't they have included it? Had they known, Your Honor, that this happened in 1985, before they filed the information against Rudy Salas, certainly they would have included it. The information against Rudy Salas in the lower court in 1985 states, among others, the enumeration there is not exclusive of the offenses allegedly committed by Rudy Salas as the leader of the Communist Party of the Philippines, the New People's Army.
Now, do you agree with me, Attorney Sanidad, that there is no factual findings yet as to the 15 counts of murder allegedly committed by Rodolfo Salas were acts made in furtherance of rebellion?
Your Honor, the resolution of the prosecutor attached to the information or upon which became basis specifically states that it was committed by the Communist Party of the Philippines and the New People's Army. They're armed. Why? Because they were out to root out government spies. So it was committed by that illegal Communist Party, the Communist Party which my client is the leader at that time.
In the informations filed before the court of Judge Medina, how many informations were filed? 15 counts of murder, right?
Yes, Your Honor, but it is integrated only in one information.
In one information,
Yes, Your Honor.
okay. Now, can you see whether the information states that the crimes of murder, the 15 counts of murder were committed in furtherance of rebellion?
Your Honor, it is implied. May I please be allowed to read, Your Honor?
Yes, please.
Information. People of the Philippines versus Jose Maria Sison et al., of which Mr. Salas is named. The second page, Your Honor, after stating the names of the accused, that second paragraph so states, and I would like to read for the court, open quotes, that on or about the months of May and June 1985, and for some time prior or subsequent thereto, at Sitio Mount Sapang Dako, Barangay Kahulisihan, in the municipality of Inupacan, province of Leyte, Philippines, within the jurisdiction of this honorable court, and I would like to stress this part, the above named accused, being members of the central, regional, and provincial committees, arresting, investigating, and or execution teams of the CPP-NPA. There, Your Honor. These offenses, therefore, were committed by the CPP-NPA, of which Rudy Salas admitted to as a leader in 1991 and was convicted thereof. Therefore, these offenses are absorbed insofar as Rudy Salas is concerned only, Your Honor. I am not saying that this applies to all the other accused in Ocampo. Why? Because all the other accused in Ocampo, aside from Mr. Salas, does not have the benefit of a prior conviction.
No. So, can the court now, through a writ of habeas corpus, nullify the entire criminal proceeding based on a finding of double jeopardy?
Not the entire, we are not asking this court to nullify the entire proceedings, Your Honor. We are just asking this court to look into the information, look into the resolution, compare it with the decision of in 1991 that convicted Mr. Salas, and see if there is indeed double jeopardy. The only thing that can be done is this court will order the nullification of the charges insofar as Mr. Salas alone is concerned. It has nothing to do, Your Honor, with the validity of that information which was upheld in Ocampo by this court, insofar as the other accused. Only as to Mr. Salas, Your Honor, because of that sui generis situation that Mr. Salas has, a prior valid conviction for rebellion.
Thank you, Attorney Sanidad.
Thank you, Your Honor.
No. Okay. No more, but I have to ask the...
Go ahead, Justice Garland.
Okay. Thank you, Attorney Sanidad. Now, can I also, Mr. Chairman, can I also ask also profound
Yes, yes,
questions
please.
to the respondents, to
Yes,
the,
please.
to the
Counsel for
honorable,
the respondents, please take the podium.
yes.
Please remove your bottled water so as not to transmit the COVID virus.
Good morning, Mr. Solicitor General.
Yes, Your Honor.
Now, on the claim that petitioner's arrests and subsequent detentions were effected through a lawful process,
Yes, Your Honor.
is the rule that habeas corpus cannot lie when a person is detained under a lawful process an absolute rule, or does it not admit of any exceptions?
Well, normally there are certain exceptions, Your Honor.
So there is a presumption that all legal processes are lawful. Is that what you mean?
Yes, Your Honor. They are presumed to be lawful, Your Honor.
It is settled that the presumption of regularity can be overturned by clear and convincing evidence to the contrary, right, Mr. Solicitor General?
When the trial court will find the factual issues, Your Honor, then we will look at that order of the trial court, Your Honor.
So this applies in proving that a lawful process is not lawful at all.
Beg your pardon, Your Honor.
So does this apply in proving that a lawful process is not lawful at all?
Well,
Because it is settled that the presumption of regularity can be overturned by clear and convincing evidence to the contrary. Because we are talking about the legal process as lawful. That's the reason why you are claiming a while ago that because of a lawful process, then the petitioner cannot avail anymore of habeas corpus, but instead he has to avail of other remedies before the regional trial court, like a
Yes.
motion to quash the information, or even ask for a reinvestigation of the case if he is not yet arraigned.
that's correct, Your Honor.
So, okay, let's just go on to other questions then. Okay. Now, we mentioned earlier, you mentioned earlier that the available remedies to the petitioner right now is to file a motion to quash or even to ask for a reinvestigation of the case.
That's correct.
Are these the only available remedies for Mr. Rodolfo Salas? Can
Well,
he not avail of other extraordinary remedies like this, because it involved his fundamental constitutional right to due process, which includes the right of liberty and, of course, the right to life? Can he not avail of habeas corpus petition for the issuance of a writ of habeas corpus?
Well, Your Honor, as I've stated in my opening statement, the factual issues should be first thrashed out by the regional trial court, Your Honor, which has already jurisdiction over him.
Because it is correct me if I'm wrong, it is your stand that in as much as there is already a legal process in the confinement of Mr. Rodolfo Salas, then he can no longer avail of the extraordinary remedy of habeas, a petition for a writ of a habeas corpus. In fact, you said that a petition for habeas corpus cannot be a substitute for other remedies like appeal and so on?
With respect to this case, Your Honor, no. He should not have filed this writ of habeas corpus.
For how long will a trial court determine the merits of a motion to quash? Do you have any idea, Mr. Solicitor General?
I would presume that the RTC judge will hasten this matter, Your Honor. I cannot, at this time, I do not know when and how long it will take, but I have faith, Your Honor, in the judges of the RTC.
So it will be at the mercy of the court. I mean, the security of of an accused charged of a non-bailable offense will be at the mercy of the court, because until such time that the motion to quash is addressed or decided by the court, then the petitioner or the accused, for that matter, will be in confinement. Am I correct?
As I said, Your Honor, I have faith and confidence in the ability of the judges of the regional trial court, Your Honor.
Well,
I
I'm
don't think
sure.
they will drag this for a long time.
I'm sure that you know also how long will it take for a reinvestigation to be resolved. How long will it take for a reinvestigation to be resolved if that will be the remedy that Mr. Rodolfo Salas will avail?
Well, I cannot hazard a guess, Your Honor, but I believe his rights will be protected in the RTC, Your Honor.
Now, considering the advanced age of Mr. Rodolfo Salas, I don't know about his health right now. Can he not avail of the remedy of the writ of for this petition of habeas corpus?
Well, this should be remanded to the RTC. That's my suggestion, Your Honor.
Now, in the double jeopardy, can habeas corpus be availed to determine the existence of double jeopardy, Honorable Solicitor
Well,
General?
in the first place, we should look at the facts of the case, Your Honor. And the one who can do that is the RTC, Your Honor.
It is the RTC.
Yes.
It is not for this court to determine factual issues as to the double jeopardy.
That's our position, Your Honor.
Now, on Rodolfo's 1991 plea bargaining, I'm sure you are very well aware of the plea bargaining of Mr. Rodolfo Salas in 1991. No. Now, generally, what is the definition of a plea bargaining agreement?
Can I
Yes,
look
please.
at my notes, Your Honor?
This is the decision in plea bargaining.
I think that's it.
Let the prosecution and the defense.
With the consent. I have here, Your Honor, the decision of the Regional Trial Court, Branch 12 of Manila, concerning the plea bargaining, Your Honor.
Okay. Anyway, it will be asked by one of my esteemed colleagues here. I just want to have another question pertaining to the plea bargaining. It's anyways just a a general statement. Once a plea bargaining agreement is approved in court, do the terms stated therein become immutable, Mr. Solicitor General?
Well, the word immutable is quite strong, Your Honor, so generally it will be, but there might be other circumstances which I cannot fathom as of now, Your Honor.
Thank you,
Thank
Mr.
you, Your Honor.
Solicitor.
Thank you, Justice Garland. Can I now ask Justice Alex Esmundo to proceed with his interpellation questions?
Thank you, Chief. May I ask counsel for petitioner a few questions? Can you have with you a copy of Annex A of your petition? Thank you. Earlier, you made a manifestation that you were part of the legal team that negotiated the plea bargaining arrangement.
Yes, Your Honor. In fact, my name appears, Your Honor,
I
in
saw
the...
I saw your name in the decision as having
Yes, Your Honor.
signed it.
On page 8, Your Honor.
That's correct. Is it your position that this plea bargaining agreement provided an absolute and perpetual immunity to the petitioner, to Mr. Salas?
As long as the offense, Your Honor, is covered by the conviction.
By the
And that,
rebellion?
yes, Your Honor, it would, Your Honor.
Now, if you look at page 2 of the decision,
Yes, Your Honor.
paragraph 1, it says there, conducting armed raids. Do you see that?
Yes, Your Honor.
There's a specific enumeration of places purportedly where Mr. Salas committed crimes against innocent civilians.
Yes, Your
Correct?
Honor.
Is there a mention of Inupacan, Leyte?
None, Your Honor.
You are saying that Section 2E of the plea bargaining agreement provided that absolute and perpetual immunity as appearing in page 7 of the
Yes, Your Honor, to offenses committed in furtherance of rebellion, Your Honor.
Is there a time frame mentioned in that provision?
The time frame here is mentioned is the decision itself when he was the leader, Your Honor, of that rebellion, which
Are you
under
s-
the information for which he was charged, sorry, Your Honor, under
Okay.
the information for which he was charged then is from 1970 to the time he was arrested in 1986.
That's correct. However, the information recites specific instances subject of the information on which he was convicted. Did it include the incidents in Opacan, Leyte?
No, Your Honor, it did not include the incidents in Inupacan,
So
Leyte.
there is no mention at all, either in the information and the plea bargaining agreement, about the present subject of the 15 murder cases. Is that correct?
Yes, Your Honor, but the information itself and the decision mentions such as and among others, Your Honor.
That's correct.
Meaning that these are only examples of the overt act committed in furtherance of rebellion. And as I said earlier, positing, if we were there in 1986 when they filed the information, and this offense was already committed or discovered then, I am sure it would have been included, Your Honor.
Is it not the principle in criminal law in People versus Tiansay that for purposes of filing information or prosecution, the discovery of the crime should be the reckoning period?
Only for purposes of prescription, Your Honor. For
Yes.
purposes of liability, it should be when the offense was committed. And that is another offense there. This is rebellion, Your Honor. This is covered by the Hernandez Doctrine. It is totally a different situation, Your Honor.
If that is the case, is it possible for the state to grant absolute immunity when there is no crime charged yet?
Your
I
Honor,
mean,
it is
can
a...
just a moment.
I'm sorry,
Can
I'm
the
sorry.
state grant absolute immunity without knowing whether is such crime committed or that crime will arise later?
Of course not, Your Honor. But when that crime is discovered and it is part of the overt acts of rebellion for which one has been convicted, it would fall now and be absorbed under the Hernandez Doctrine.
So in other words, you are insisting that this Section 2E is a blanket immunity.
No, Your Honor. It only is an immunity insofar as political offenses or common crimes committed in furtherance of rebellion from 1970 to the time he was arrested in 1986.
If that be the case, why did you not add that colatilla in 2E?
Pardon, Your Honor.
If that is the case, and that was the intention of the parties to the plea bargaining agreement, why did you not put that in 2E, as provided in the immunity agreement?
The immunity agreement which
You read
adopts
section 2E of page 7.
that both accused will be covered by the mantle of protection of the Hernandez and Rile political offense doctrine against being charged and prosecuted for any common crime allegedly committed in furtherance of rebellion or subversion.
Okay, why did you not put a clause that now subject of the present case and thereafter?
Your Honor,
If that was the intention.
Your Honor, the intention here is based on the doctrine of Hernandez.
Correct, but
Yes,
the-
Your Honor. That would, to us, that would be already, to me, Your Honor, honestly, to me, that would be surplusage already, Your Honor. Because the doctrine of Hernandez says, offenses committed in furtherance of rebellion at the time, up to the time he was convicted. And therefore, this offense, if discovered then, I am sure would have been part of this, Your Honor. Rudy Salas should now be given that protection, Your Honor, of future charges of offenses committed in furtherance of rebellion at the time, 1970 to 1986. After that time, Your Honor, if there is any other offense that can be charged to him, then the Hernandez doctrine would not apply.
Would it not have been more clear if you stated in 2E something to the effect that the present charges or hereafter that may be filed against in connection with rebellion?
I suppose it
So
would,
to avoid the ambiguity now?
I suppose it would have been, looking back, Your Honor, if I knew, I would have been more specific as to this aspect, Your Honor. But when we agreed with the Department of Justice, that is the intention, Your Honor, for future common crime, for common crimes discovered that may have been committed in furtherance of rebellion.
You know, we will be dealing with parole evidence rule now because this is a plea bargaining agreement.
Actually, Your Honor, it is not a plea, based on the decision. This plea bargaining agreement was taken into consideration only for purposes of the penalty. The plea bargaining agreement, of course, stands as a plea bargaining agreement. It binds the government because it is part of the decision of conviction.
That is your contention.
Yes, Your Honor.
But if you read the entire text or context of the decision, the plea bargaining agreement is the basis for allowing the reduction of the penalty and allowing the Salas to withdraw his earlier plea of not guilty to guilty to a lesser offense. So the decision must be read in its entirety and context.
If the decision is read in its entirety and context, Your Honor, it is a conviction for rebellion. And therefore, any and all acts committed in furtherance of the rebellion from 1970 to 1986 is part of that conviction.
But-
I can also say that even without that agreement, if he was convicted of rebellion at that time, this offense would still be absorbed because of Hernandez and the other cases, related cases.
So you are telling us now, even with the provision of 2E, you will still invoke the doctrine of
Double
Hernandez?
jeopardy, Your Honor?
Double
Yes, Your
jeopardy.
Honor. Yes, Your Honor. The protection here is, in fact, as far as Mr. Salas is concerned, is twofold, or threefold, I would say. One is the conviction. Two is the agreement. Three is the doctrines of People versus Hernandez.
But you will agree with me that now, under the circumstances, this will be in the nature of parole evidence rule now, that we would interpret the section 2E.
I would not think so, Your Honor. The judgment itself is the evidence before this court, Your Honor. It is a judgment of conviction for rebellion, which this court should take cognizance of as a final judgment.
But you are arguing and stating that section 2E provided the absolute immunity.
I am saying, Your Honor, that it is part of the doctrine of res judicata and conviction for rebellion. It further explains the nature of the conviction of rebellion insofar as Mr. Rodolfo Salas is concerned. And that is why, Your Honor, this distinguishes Mr. Salas from all the other accused in the Ocampo case, Your Honor.
Let me move to another point, Mr. Counsel. What's the status of health of the Mr. Salas, subject of the petition?
He's not in his healthy, in a healthy way, Your Honor.
How old is he now?
He's 72, Your Honor.
Okay. Would you not consider availing of the doctrine in Enrile?
That is one we would like to ask to Your Honor. But basically, considering that the closest basis for his bail would be the very case of Ocampo, of which he is charged of, where this honorable court granted bail, Your Honor, to Ocampo, while that case is proceeding and while the Supreme Court was resolving the petition, Your Honor. So that is why, that is the immediate immediate jurisprudence and act we are asking this court, Your Honor, to apply equally to Mr. Rodolfo Salas. Your Honor, since you raised the health situation, Your Honor, we are fearful. This court can take is of public knowledge and judicial notice how cramped the Manila City Jail is concerned. He stays now in a 3 by 1.5 foot bed with 3 or 4 others up and beside him.
That's why the court asked you if you are willing to avail of that doctrine.
We are, Your Honor, if it would give Mr. Salas immediate release, Your Honor. In fact, there are 2 ways by which Mr. Salas can be given to restore his liberty, Your Honor. First, free, with the suggestion of Your Honor. First is the grant of the petition. Second is the grant of the bail for temporary liberty. The third, which is more permanent in sense, aside from granting the habeas corpus, is there a possibility, Your Honor, that the prosecution here, in good faith, was mistaken in including Rodolfo Salas? And if they realize that they made a mistake, can they not just withdraw, drop the information as against Mr. Salas only? That would already solve the problem. It would not entail this honorable court having to resolve the issue, Your Honor.
Mr. Counsel, why don't you exploit all those 3 matters before the regional trial court?
Your Honor,
so that parties can be heard, because it will obviously require factual determination.
Your Honor, it is for that very reason why we came to this honorable court. The time that would take for the lower court to resolve an issue. I gave an example, Your Honor, of 3 cases that had to go up to this court on the ground, on a motion to quash before the lower court for double jeopardy, Your Honor. And in one case, it took 10 years.
Thank you.
It is luckily only there, Your Honor, that the petitioner, Idler, was only being charged for reckless imprudence resulting in homicide, and therefore bail is available. As far as Mr. Salas is concerned, it's a non-bailable offense. That is the reason we are here, Your Honor.
Thank you, Mr. Counsel.
Thank you, Your Honor.
May I ask the Solicitor General, please? Mr. Solicitor General, you must have heard that I raised with the counsel for the petitioner the possibility, if they wish to avail of the application to bail. Would you have any objections if they should apply for bail, considering the predicament of the person subject of the petition?
Your Honor, I believe it will be the judge of the RTC who will decide that, Your Honor.
I'm sorry, I did not hear you. Please restate please say again what your reply. What, would you have objections?
I will cross the bridge when I see it, Your Honor.
Okay, we leave it to you. Thank you.
Thank you, Your Honor.
Thank you, Chief. I'm done.
Justice Rory Carandang, please proceed.
Thank you, Chief. Can Can we have the counsel for the petitioners?
Good morning, Your Honor.
The backbone of your argument for this petition is the prior conviction of petitioner's father,
Yes, Your Honor.
that he was already charged, validly arraigned, pleaded guilty to an amended information for rebellion in and he was convicted by a plea bargaining process in 1991.
Yes, Your Honor.
Incidentally, although I was not the one who presided over that court during that time, I presided over that court after. So I haven't read the case. It's only now because I did not have time to recover the case of Mr. Salas, but it was told to me by the staff. Can we go to Annex A?
Yes, Your Honor.
The decision rendered by the Branch 12 Trial Court of Manila.
Yes, Your Honor.
Can we go to the third paragraph of the first page of the decision?
Yes, Your Honor.
Can you read it?
On October 24, 1986, the prosecution filed an amended information charging him and his two co-accused of the crime of rebellion under Article 134 in relation to 135 of the revised penal code as amended, alleged to have been committed as follows. Shall I continue, Your Honor?
Yes. Yes, please.
That in or about 1986 and for some time before said year and continuously thereafter until the present time in the city of Manila and elsewhere in the Philippines, the Communist Party of the Philippines, its military arm.
Can I interrupt you?
Yes, Your Honor.
So there is a specific date.
Yes, Your Honor. A specific period, Your Honor.
It's 1968,
Up to the present time, Your Honor.
which was 1986.
Yes, Your Honor.
Okay, so that's clear.
Yes, Your Honor.
For acts committed between 1968 to 1986.
Yes, Your Honor.
Okay? Let's go now to the specific acts covered by the decision based on compromise agreement and plea bargaining.
Yes, Your Honor.
What are these specific acts, counsel?
What?
You can read through.
In the plea bargaining agreement, Your Honor, or
In the decision.
in the decision?
Because these are
The
the
specific acts are from page 2, Your Honor. up
page
to-
2, it's
to page 3, page 4, Your Honor. Shall I read all, Your Honor?
okay, until
Page 4, Your Honor.
4. Okay. Would you agree that the acts committed here are acts committed against the forces of the government?
Yes, Your Honor.
Okay. And
And including, pardon, Your Honor, there is a statement including civilians, Your Honor.
yes. Civilians. But the murder allegedly committed in 1985, which is subject of this information, are killing of comrades.
That is what is alleged in the,
Killing of killing of members of the organization who were considered to be traitors
Yes,
of the
Your Honor.
organization.
yes, Your Honor.
So you consider that as civilians?
No, Your Honor.
No. How do you consider them in the context of
They are on the belief that they were government agents, they are therefore enemies,
government
Your Honor.
forces?
Yes, Your Honor.
Okay.
And therefore, the case of Agarin should apply, Your Honor.
The case of?
Agarin, people versus Agarin, where the Huk Balahaps killed some of their comrades whom they believed to be government spies, Your Honor.
So they were considered as civilians.
I don't think they were considered, yes, they were not considered civilians, so they were considered as enemies.
Government enemies forces then,
Yes, Your Honor.
part of the government.
Well, in the belief of the Huk Balahaps, Your Honor.
Okay. So there is a specific date mentioned here in this decision, and the period is up to 1986.
Yes, Your Honor.
So we are clear on that.
Yes, Your Honor.
Let's go to the information for murder for this case. Annex C. the information is, the shortened version of the information is what was read, but you will agree that the part of the information is the resolution of the prosecutor's office or the Department of Justice in this case, consisting of 1, 2, 3, 4, 5, 6, 7,
Yes, Your Honor.
filed on February 2007. And this is the basis of the information filed
February 16, 2007, Your Honor. Yes, Your Honor.
2007. Can we go to page 2?
Yes, Your Honor.
There is a first paragraph, second paragraph, third paragraph, starting with the word witnesses.
Yes, Your Honor.
Can you read it, please?
Witnesses for the complainants, including the relatives of the above-named victims, claim that in the year 1985 up to the year 1992, there were at least 100 persons residing in the adjacent barangays and municipalities of Sitio Sapang Dako, Barangay Kaulisihan, Inupacan, Leyte, who were seen to have been abducted, hogtied, tortured, and executed by the elements of the CPP-NPA.
Can I interrupt you, please?
Yes, Your Honor.
So that there is a specific period,
Yes, Your Honor.
1985 to 1992.
Yes, Your Honor.
And definitely this is not included in the 1986 acts committed.
Yes, Your Honor. At that time, Rudy Salas was already in prison, Your Honor.
How do you reconcile that with the Hernandez case?
Your Honor,
Is that-
the acts committed here were committed in 1985. The
85.
1985, Your Honor. So therefore, it falls within the original information, which is 19... Ano ulit yun? Up to 1986.
But there are,
That on or
witness-
about 1968 and for
68
some
to
time
1980.
before said year and continuously thereafter until the present time, which is
1986.
May 10, the decision, Your Honor. Yeah, 1986. Yes, Your Honor.
So the acts after 1986 are not included.
No, Your Honor.
But
Because
you are clinging to the principle of enunciated in the Hernandez case that
Yes, Your Honor.
everything is included.
Pardon?
Everything is included.
Everything
Every
with-
common crime. Every crime
Not all crimes. It has to be committed in
in
furtherance
furtherance of rebellion.
connection or in
with
furtherance.
rebellion.
Yes, Your Honor.
That's precisely the point.
Yes, Your Honor.
So it's your position that it should not end in 1986, but it should go forward.
No, Your Honor. Insofar as an
No,
offense...
the compromise agreement should not end for acts committed in 1986, but it should go forward.
Only for acts committed within the period from 1968 to 1986, Your Honor. If after he was released from prison, because he was detained from 1986 to 1992, if he committed acts after 1992, the prosecution should distinguish, should file those cases. But these are not, there are no acts charged in the information committed after 1985, Your Honor. The acts here are committed specifically based on the testimony were done in 1985.
But very clear is the statement in the resolution that witnesses, and you read it,
Yes, Your Honor. But if
from
you,
the year 1985 up to 1992.
yes, Your Honor.
So these
But-
were series of acts.
Yes, but he was in prison, Your Honor. He was already captured, detained, serving sentence, Your Honor.
When?
So, from 1986
To?
to 1992, Your Honor. So, how can we now attribute personal liability for a crime committed when he was already under government detention, serving sentence, Your Honor?
From 1986 up to 1992.
Yes, Your Honor.
Did you note that?
Pardon?
Did you note that he was under detention from 1986 up to 1992?
I am sure it is in the petition, Your Honor, because he served sentence for 6 years and 1 day. In fact, his service of 6 years and 1 day went over because they did not compute his good time allowance. So it went beyond 3 months. He should have been released He was released on September 29, 1986. He should have been released July, but the BMP forgot to integrate and count good time allowance.
So he was released in,
September 29, 1992, if I am not
by
mistaken.
virtue of his conviction in the rebellion
Yes,
case.
Your Honor.
Okay. So that's very clear to me. Let's go back to the specific acts covered by the plea bargaining. There's several.
Yes, Your Honor.
There are several, and the alleged murders in later are not included in this.
Yes, Your Honor, because at that time they were not yet known, Your Honor.
Okay. Can you plea bargain for an offense that is committed in the future?
No, Your Honor. But here, the offense here were committed within the period for which he was convicted, Your Honor. And therefore, that should be included under the Hernandez Doctrine.
Can you plea bargain to something which you do not know, which you were not charged of?
No, Your Honor. But under the Hernandez Doctrine, again, Your Honor, any offense committed in furtherance or in connection therewith, it need not be specified. Once a person is convicted of rebellion, it absorbs all these offenses, Your Honor. It need not be specified.
During the period from 1986 to the time of his release, in 1992, was he held incommunicado?
Well, no, Your Honor. That would be a violation of his constitutional right, Your Honor.
Can he talk to his comrades in the
Well, that
organization?
would depend upon the rules and regulations of the jail, Your Honor.
What?
That would depend upon, I really don't know the rules and regulations of the place of detention, Your Honor, whether friends and other persons can visit. But as a rule, the family could, of course.
There are other persons who could visit him,
I am not sure, Your Honor.
okay? And these persons are not, you don't know these persons.
Well,
They
I
can
don't
be
know.
comrades, there can be allies in the organization, relatives, friends.
I do not know who visited him, Your Honor.
Okay. Those are just the few points that I would want to raise.
They are good points, Your Honor.
Good points? Good
Yes,
points
Your
for you?
Yes, Your Honor.
Bad for the government?
Well, good points in the sense that, Your Honor, this court is being enlightened on the position of the petitioner and the continuous violation of his rights.
As regards your invocation of the power of the Supreme Court, so you think the question here is a very legal question,
Yes, Your Honor.
which the trial court cannot just decide like that?
It can decide it, Your Honor, as I said earlier, and it has decided in certain cases. But it's a question now of how long will it take for the issue to be finally decided, because it is a constitutional issue. In two cases I cited earlier, one case, Eivler, it took almost 6 years before this very court said, "Oy, double jeopardy yan." In the other case, it took again another 4 years before went up to this court, and this court said, that is double jeopardy.
But
so
it ha-
if we go through the process, Your Honor,
But
there is no assurance.
But it has to be determined that these murder cases are absorbed.
Oh
in-
yes, Your Honor. Of course, Your Honor. It has to be determined that People versus Hernandez, the doctrine of People versus Hernandez applies. And we believe it applies.
Is it proper for us to determine that or for the trial court?
It is for you, Your Honor, considering that it is a constitutional issue being brought to you now. The constitutional issue of liberty of the person of Rudy Salas, Your Honor.
But there are factual matters to be resolved here.
I agree, Your Honor. But habeas corpus should not be limited to the face of the petition alone. That is the purpose of the great writ of liberty. As I cited earlier, it is of protean reach. It is not bound. The rules are set by you in order to uphold one's liberty. That is the purpose of the great writ of liberty called habeas corpus.
We go back to the bail granted to sa Turo Campo, this was granted by the RTC, not the court.
No, Your Honor, it was granted by this court, Your Honor.
It's granted by this court in
If
this
my
petition.
reading of the decision is correct, Your Honor, it was granted by this honorable court. And it was-
Chinese by losses Ladlad were given provisional release on the basis of their cash bond for 100,000. But for Mr. Ocampo, he was given bail by this court.
Can I read, Your Honor? Yes, Your Honor, he was given bail by this court. It was this very court that granted him bail, Your Honor, pending that. In fact, it's that if I am the decision states that he is granted temporary liberty under bail, while that case before Judge Bunyi is being resolved, tried.
So this court is the one who granted the bail to Mr.
Based on
Ocampo.
my reading, Your Honor, yes, Your Honor.
And the
That is
basis
why-
for and
that
the
is why
basis.
I'm asking for the same treatment to Mr. Salas, Your Honor. There is more basis to grant bail to Mr. Salas.
And the basis for the grant is because there was an ongoing peace process.
As far as Mr. Ocampo, Your Honor, no. The
No?
basis of Mr. Ocampo is while the case is pending before Judge Bunyi. The other accused, yes, Your Honor, I agree, while there is a peace process.
So for the grant of Mr. Ocampo's bail, there was no condition that it was because
While
of the peace
the-
process undergoing during
No,
the
Your
time?
Honor. The grant of the bail for Mr. Ocampo, specifically, Your Honor, is until the case before Judge Bunyi is
Is
resolved.
terminated.
Yes, Your Honor.
Okay. I think I'm through with the counsel for the petitioner.
Thank you again, Your Honor.
Uh,
It's a pleasure, Your Honor.
Can we have this, Mr. Solicitor General? So offhand now, you cannot convey the sentiment of the government that Mr. Salas can be granted bail, following the doctrine in Enrile.
Well, it's up to this court, Your Honor, to decide whether he should be given a bail.
So it's
But-
up to the court.
Yes, Your Honor. But if you will read our sentiments, Your Honor, how about those 15 persons who were massacred? How about their relatives? They have waited for so many years for justice, Your Honor. So there should be a balancing here of sentiments, if I may say, Your Honor. I understand the predicament of the accused, but how about the victims, Your Honor? The relatives of these victims, aren't they also entitled to justice?
Okay, Mr. Solicitor
Yes, Your
General, I will be asking the same questions I propounded to the counsel for the petitioner. The basis of the decision are acts specifically committed. There are specific acts committed as stated in the decision. And they say, petitioner says, that even with the enumeration of those acts not discovered during that period are covered by are absorbed because these are common crimes absorbed by rebellion. And they are anchoring their position on the decision rendered by the court in the Hernandez case. What can you say about it? Is it time-bound? The decision is time-bound?
What I can say, Your Honor, is the facts should be unearthed.
What, Mr. Ram?
The facts of the case should be unearthed, Your Honor.
No. In the coverage of the conviction for rebellion, the acts allegedly, the acts committed for which Mr. Salas pleaded are acts committed up to 1986. So it is time-bound. Acts committed only up to 1986.
I cannot discuss about the time bound, whether it is
You can-
yes,
you
Your
can-
Honor.
you
Because these
can-
are factual issues, Your Honor, that has to be threshed out by the RTC judge, Your Honor.
You can put that in your memorandum, which I think the court will require you to
Yes, Your Honor.
submit. Also, the question relating to the specific acts included in the decision and the alleged murder that happened in Leyte are not included in those acts
Yes,
mentioned in the decision.
we will do that, Your Honor.
But they're saying that these acts are included because these were acts committed from 1985 up to 1992 when Mr. Salas was serving his sentence. Because the information was very specific, the resolution was very specific, that the crimes, that the alleged acts were committed from 1985 up to 1992.
The fact that the accused was in jail for that certain period, Your Honor, doesn't mean there can be no conspiracy.
So I
And
think
he belongs to the top echelon, Your Honor, of the Communist Party of the Philippines.
So I think you should have to include that in the memorandum also,
Yes, Your Honor.
both of the parties. And these
Yes,
are
sir.
only the specific questions that I am raising now.
Thank you, Your Honor.
Thank you,
I'm
Justice
through.
Carandang. The parties and everyone is informed that since this is habeas corpus, the court will not adjourn until we finish the interpellations of the justices. So, Justice Salameda, please go ahead.
Thank you, Chief. Just a few questions for the counsel of the petitioner.
Yes, Your Honor. Yes, Your Honor.
Mr. Counsel, this is a theoretical question.
Yes, Your Honor.
When is an information sufficient? What are the requisites for the sufficiency of an information?
That the elements of the offense are enumerated, that it has the name of the accused, and that it states that the court under which it is filed has jurisdiction over
The
the
date
offense.
and time.
Date and time, Your Honor.
Yeah. Place, date and place, rather.
Yes, Your Honor.
Okay. Now, on the basis of the information filed herein, is the information sufficient?
Pardon, Your Honor.
On the basis of the information filed herein against your client, is the information sufficient for the crime of murder?
It is sufficient for the crime which is alleged in the body, Your Honor. Because the ruling of this court is what governs the nature of a crime in an information is not the title. It
Yes.
is the specific allegations.
Yes, that's what I am asking you.
yes.
So, Mr. Counsel, your client, you're saying that your client can be convicted for murder on the basis of the information filed by the prosecution. Am I right?
Yes, Your Honor.
Okay. Can you go over the information, please? Starting from conspiring and confederating.
Yes, Your Honor.
Please read it.
Which
Conspiring and
the information before Judge Bunyi, Your Honor?
Yes.
That on or about the months.
Conspiring, start with conspiring and confederating and helping one another with intent to kill.
Conspiring, confederating, and helping one another with intent to kill, employing treachery, evident premeditation, and taking advantage of their superior strength, did then and there willfully, unlawfully, and feloniously.
Please stop, Counsel.
Thank you.
Do you know the case of People versus Solar E. Dombrigue?
I'm sorry, Your Honor. I do not, Your Honor.
Anybody from your new lawyers? Because this was promulgated only on August 6, 2019.
I'm sorry, Your Honor. I am not aware of the case, Your Honor.
So, in People versus Dombrigue, it says here that the ultimate facts constituting the aggravating or qualifying circumstances for murder should be specifically stated in the information to have a valid information.
Yes, Your Honor. As part and parcel of the information pursuant to Rule 110, Section 8 and 9, Your Honor.
Can you go over the information again if the ultimate facts constituting the aggravating or the qualifying circumstances were stated therein?
Yes, Your Honor, I agree. The qualifying circumstances are stated. But who committed this offense and under what circumstances were this offense committed?
I do not agree with you, counsel, because the information merely states the aggravating or qualifying circumstances of treachery, evident premeditation, and taking advantage of their superior strength. There should be the ultimate facts in the information included to specifically describe these aggravating or qualifying circumstances.
May I, Your Honor, reply? Yes, Your Honor, insofar as aggravating and the qualifying circumstances. But who is the offenders, or who are the offenders? Under what conditions did they commit it? That is the paragraph before it. And I would like to read, Your Honor, the context in which these qualifying circumstances were committed.
So
Can I be allowed, Your Honor?
What I'm saying, counsel, is that if these aggravating or qualifying circumstances are not stated with specification herein, he is only charged for homicide.
Yes, Your Honor.
And under this court, you have suggested previously that the court can either grant the writ of habeas corpus in favor of your client, or number two, the court will allow him to post bail. Number three, the prosecution to withdraw the information, and I now suggest another, number four, for your client to be arraigned and later ask for bail because the arraignment is in the basis of the information for homicide.
Your Honor, why should we now admit to an information which is invalid either for murder or homicide, Your Honor? Because our position is, it is absorbed. Whatever the offense, with the homicide, murder, arson, all of these crimes under People versus Hernandez, which is inclusive in waging war against the government.
But counsel, you are ultimately asking for the immediate release from custody of your client.
Yes, Your Honor.
And this is another option.
Well, it is not. It is an option, Your Honor, but it is similar to our objections to filing a motion to quash. How long? Is it the proper remedy? I cannot tell the judge, can you please decide it today and have my client released tomorrow, or decide it so that if we have disagreed, I can go up again to the Supreme Court? That is why I mentioned two cases, Your Honor, where the remedies before the lower court are not viable, adequate, and speedy. Only in the case of Mr. Salas, Your Honor.
So if you think this is not viable, we go to another point, counsel.
Yes, Your Honor.
So your client here is charged for murder, not for rebellion.
Yes, Your Honor.
And consistent with the position taken by Justice Esmundo, you have to establish here the case of Ocampo versus Abando, that the court, it is essential for the court to determine whether the act of killing was done in furtherance of political end, as well as the political motive of the accused.
Yes, Your Honor.
So that it will fall under,
People versus
it will be
Hernandez.
absorbed by the crime of rebellion.
Yes, Your Honor.
Okay? So, do you think that in saying this is a matter of defense which should be threshed out in the court below?
No, Your Honor.
Please explain.
In the case of Ocampo, the court indeed ruled, and in all other cases, Lopedario, all cases where common crimes were filed against alleged rebels, this court said, hey, the political offense doctrine and People versus Hernandez can only be applied in a two-step process. This two-step process is, one, you have to admit you are a rebel. Two, you will have to prove that that act for which you are charged was committed by you as a rebel. In this case, Your Honor, he does not need to admit he was convicted. And that convicted of rebellion, convicted of being a leader of the CPP-NPA from 1986 to 1968 to 1986. Therefore, Your Honor, utilizing People versus Hernandez, it is absorbed. He is protected by that doctrine.
So your position is that it is not a matter of defense. The court,
For-
this court should automatically dismiss the case because
No,
it
Your
is
Honor.
absorbed by the
For
crime.
other persons who have not been convicted and cannot claim the protection of double jeopardy, yes, it is a defense. For those persons who cannot claim the protection of double jeopardy, it is a defense for a lower penalty, actually. It is not a defense for acquittal. Here, double jeopardy insofar as Rudy Salas is concerned is a defense for absorption and to be set free.
That's all, counsel. Thank you.
Thank you very much to Your Honor.
Can I ask the Solicitor General for one question? Mr. Solgen,
Yes, Your Honor.
good morning.
Good
Can-
morning also, Your Honor.
Can you explain to us why the prosecution included the phrase herein in the information being members of the central, regional, and provincial committees arresting and investigating on execution team groups of the CPP-NPA, considering that this is not an element of the crime of murder?
Can I look at the information? Your Honor? The information was crafted by Assistant Provincial Prosecutor Vivero, Your Honor. Maybe he just added that phrase, Your Honor, to show what was the position of the accused then at that time, Your Honor.
Is this not an acknowledgement that indeed the acts committed here is in furtherance of rebellion?
Not necessarily, Your Honor.
Because this is not an element of the offense.
That's right. It may be a surplusage, Your Honor.
That's all, counsel.
Thank you, Your Honor.
The Honorable Solgen, can you please remain in the podium? I will ask questions from you first. Your position is that an ordinary regional trial court can rule on the constitutionality of issues. Is that correct?
Yes, Your Honor.
Yes. And an ordinary regional trial court, despite simply being a regional trial court, can also rule on the basis of constitutional rights. Is that not correct?
That's correct, Your Honor.
And that you trust that our judges, not only the justices of the Supreme Court, know their constitution. Is that
Yeah.
not correct?
Yes, Your Honor.
And that judges are very much aware of this primordial and fundamental right of liberty that is not only contained in Section 1 of Article 3, but is implicit in most of the sections under Article 3. Is that not correct?
That's correct, Your Honor.
Is there any reason for you to doubt the competence of the Honorable Judge Bunyi of the Manila Regional Trial Court
None, Your Honor.
in terms of knowing her constitution? Is there any reason to doubt, based on the facts of this particular case, insofar as the murder charges are concerned, that she is not competent to handle this case?
She
Is there
not.
any reason for you to doubt that she is not competent to handle the case?
I have no doubt, Your Honor.
Okay. Is bail, when requested, an admission of guilt? Or is it a remedy that is guaranteed by the Constitution, flowing from the presumption of innocence? In other words, if the parties request for bail at the lower court or even at the Supreme Court, can that be considered as an admission of guilt for the charges for which the bail is being secured?
Not necessarily.
No, it is a right guaranteed by the Constitution in relation to crimes which are not punishable by reclusion perpetua or life imprisonment, and there needs to be a petition for bail otherwise. Is that not correct?
That's correct.
Yes. And do you have any doubts that the regional trial court judge cannot hear or will not hear or has refused to hear a petition for bail or an application for bail? Would you have knowledge?
I said, Your Honor, that I trust the judge, Your Honor.
Has there been an application by the detainee, on behalf of the detainee, for bail with the regional trial court judge? None.
None, Your Honor.
Yes. Now, let's look at the precedent of Enrile versus Salazar. Would you agree with me that that case is extraordinary and sui generis?
Yes, Your Honor.
And that in that particular case, even granting the majority's opinion, that there was proof that there was a certain health condition on the part of the accused in that case.
Yes,
Is that
Your Honor.
not correct?
Correct, Your Honor.
Although, of course, there was a very strong dissent which said that he doubted whether or not such health condition exists, correct?
Correct, Your Honor.
It was a very cogent dissent, correct?
I think so, Your Honor.
Yes. And that in that particular case, he was a senator, he was charged with plunder, and he was 91 years old. Is that not correct?
As to the age, I believe, Your Honor.
Yes. In other words, that in order even to avail of the precedent of Enrile versus Salazar, this court must have some basis to look at the health condition of the detainee. Is that not correct?
Yes, Your Honor.
And that we are not a trial court. Is that not correct?
Yes, Your Honor.
Although, of course, we can avail of the services of a commissioner. However, if there is a procedure in a lower court that is all-in-one, in other words, it can tackle the case, at the same time look at this possibility of granting bail under the extraordinary circumstances of Enrile or the normal process of bail, then perhaps it should be granted to the regional trial court. That's your theory. Is that not correct?
Yes, Your Honor.
Yes. That this is the great writ of liberty, habeas corpus. Okay. Is it the great writ of liberty because it trumps all other existing processes that are pending in any other court in the within our territory? In other words, just because there is a petition for writ of habeas corpus, an information putatively valid can immediately be suspended just because there is a petition. Is that the theory of a writ of habeas corpus?
Well, to a certain extent, Your Honor.
Or did we say in Ilagan versus Enrile, in Misolas versus Panga, in even in Humabon, that an information that has been filed already can mean that there is now a legal process to determine whether or not the detention can be continued?
Yes, Your Honor.
That is the ruling. As a matter of fact, it is contained in Section 4 of Rule 102, which was quoted by, I think it was Justice Sam Garland a while ago, that in case we do issue the writ of habeas corpus and it later on appears that there is a legal process, that it is prima facie evidence of the legality of the detention, and therefore the interpretation as of the moment is that it should be given to the court dealing with the criminal case to determine whether the detention should continue. Is that not the correct statement of doctrine?
That's correct, Your Honor.
Except for one very unique case, and that is the case of Salibo versus Warden, where in that particular case, it was very clearly shown that the detention prisoner was not the Salibo mentioned in the information and therefore a matter of mistaken identity. Is that not correct?
Yes, Your Honor.
That was also decided by the third division, correct?
Correct, Your Honor.
Yes. And that was a unanimous opinion of the third division. Was that not correct?
Yes, Your Honor.
In other words, it is a great writ of liberty because it is a writ in equity, which means if there is illegal detention and there is no other way by which a court can can be seized of the issue, then habeas corpus is the remedy. Is that not correct?
Yes, Your Honor.
And it is protean because it adjusts. In other words, absent any procedure, the court in a writ of habeas corpus, being now a court of equity, can move in the premises to correct the illegal detention, whether by bail, by commissioner, etc., for so long as there is no putative or prima facie evidence that there is another court seized of the same issues. Is that not correct?
I agree with you.
In other words, it's a great writ of liberty because it fills in the blank, just to assure that some court that is competent will deal with the issue of liberty. Is that not correct?
Yes, Your Honor.
And your theory is that a regional trial court, no matter that it is not the Supreme Court, can also deal with writs of liberty. Is that not correct?
That's correct, Your Honor.
Thank you, counsel. Can
Thank you, Your Honor.
I ask the counsel for the petitioner to take the podium?
Thank you, Your Honor.
Is rape a common crime?
Rape, Your Honor, common crime? Yes, Your Honor.
It is a common crime.
Yes, Your Honor.
Is your theory that rape can be absorbed in rebellion?
It depends if it was committed. It's far-fetched, Your Honor, I would say. I'd like to admit. But
What do you mean it's far-fetched?
Well,
In the
rape
history
is
of
basically-
insurgencies in this planet, it has been proven that in some cases, not only government forces, but also those that pretend to be rebels or insurgents have used rape as an instrument of war. And I can cite to you many feminist studies in this regard. So is rape, in your theory, included in the crime of rebellion according to Hernandez?
if it is committed with a political motive pursuant to the ruling of Hernandez, yes, Your Honor.
At this time and age,
At this time and age, I understand, Your Honor, your concurring opinion insofar as Ocampo is
not my
concerned.
concurring opinion. What is the state of the law? You mean to say that when a rebel commits rape, that can be included in the crime of rebellion given the state of the law that we have as of the moment?
The prosecution should state whether it was committed by personal motive.
No, rape, regardless.
Yes, Your Honor.
Regardless, you mean to say that it's possible to pursue a political motive by rape, given
Well,
the Magna Carta for women, given the provisions that we have under 9262, given 7610?
With the present legislation, Your Honor, I could say no.
So there is legislation to the effect which says that rape cannot be and can never be an instrument of war. Is that not correct?
I would agree to a certain
And
extent. Your
besides
Honor.
that, it is not only statute to that effect. In fact, the Geneva Conventions of 1949 and the two additional protocols, Protocol 1 and Protocol 2, in common Article 3, does say so, that one cannot be maltreated even if you are a combatant, especially if you're a combatant hors de combat, or even a spy under the custody of any insurgent group. Is that not correct?
Yes, Your Honor.
That is a correct statement of the law.
Yes, Your Honor.
As a matter of fact, Common Article 3 is even considered not only to be a treaty provision, but it is an expression of a rule of jus cogens. Don't you agree?
Yes, Your Honor.
Yes. And therefore, there are certain kinds of common crimes which are not considered, regardless of political motive, as part of rebellion.
Based on the present legislation, yes, Your Honor.
So you would agree with me that not all homicides are automatically absorbed.
Based on present legislation 9851, yes, Your Honor.
As a matter of fact, in the case of Hernandez, and if you have a copy of this, volume 99 of Philippine Reports, page 535 to 536, very clearly stating the ratio of the case. In short, political crimes are those directly aimed against the political order, as well as common crimes as may be committed to achieve a political purpose. The decisive factor is intent or motive.
Yes,
Correct?
Your Honor.
Yes. And in the case of Ocampo versus Abando, which came out in 2014, would you know if there was a dissent in that case?
There was no dissent, Your Honor.
Was that a case heard by the court en banc or by a division?
I think it was a division, Your Honor.
It was heard by the court en banc.
En banc.
And there was only one separate opinion. Is that not correct?
Yes, Your Honor. Your
But
Honor.
it was concurring in totality of the case, but went further and said that there are now certain crimes which, beyond political motive, can never be the act of a rebel. Is that not correct?
Yes, that was your concurring opinion, Your Honor.
Yes, and as a matter of fact, to be clear, the majority opinion's ratio is contained in 467 and 468, pages 467 and 468 of Philippine Reporter 726. We have already ruled that the burden of demonstrating political motivation must be discharged by the defense, since motive is a state of mind which only the accused knows. The proof showing political motivation is adduced during trial, where the accused is assured an opportunity to present evidence supporting his defense. In other words, in the case of Ocampo, the case was not remanded because there was a pending case, but because the court held that even the doctrine of Hernandez requires a factual antecedent. Would you agree with me?
Yes, Your Honor.
So, therefore, there is now existing precedent for saying that in order for us to determine whether or not the offenses relating to the 15 individuals that were the basis of this information, then there needs to be factual antecedents that need to be determined. More specifically, counsel, 67 deteriorated bodies were found in Inopacan, Leyte by the 8th Infantry Division. 67 deteriorated bodies. Out of the 67, 15 were identified. And I will read the names in their honor. Juanita Aviola, Corazon Aragon, Gregorio Eras, Teodoro Recones, Restituto Ejo, Rolando Vasquez, Junior Millapis, Crispin Dalmasio, Zacarias Casil, Pablo Daniel, Romeo Tayabas, Domingo Napoles, Siriaco Daniel, Crispin Prado, Erebreto Prado. Okay, I read them not because I am accusing your detainee of having committed the crimes, but because simply to acknowledge that they were part of the mass grave. And these were people that were identified. And I think this is the point of the Solicitor General a while ago, that we should not only invisibilize them, that they should also be known in order that we balance whatever doctrine we come out with this case. Now, counsel, were these individuals soldiers that were killed while in combat? Would you know?
Your Honor, I can only base my
Would
answer.
you know that whether these were originally members of the Communist Party or the NPA who were accused as spies? Do you have knowledge of that?
Personal knowledge, none, Your Honor.
None.
The basis, my basis.
Would you know, or would you know whether they were just ordinary civilians?
I wouldn't also know, Your Honor.
So they are the persons whose bodies are the basis of the murder charges pending now with Judge Bunyi.
Based on the information, yes, Your Honor.
But you do not know whether they are soldiers or spies or civilians.
Based on the resolution, Your Honor, that is the allegation in the resolution. The finding of
Allegation.
facts in the resolution,
But
Your
we
Honor.
are not sure, right? Beyond reasonable doubt. Neither is the Solicitor General definite at this point, neither are we. And considering that it is possible that rape is not rebellion, and that not any kind of homicide can be absorbed in rebellion, according to you, you admitted that is the state of the law as of the present, that it is possible that the murders of these individuals, maybe they were combatants hors de combat, already immobilized. Maybe they were prisoners of war. Maybe they were spies. Or maybe they were ordinary civilians. Or maybe still, the Communist Party had nothing to do with it. And therefore, we should not at this moment claim that these are deaths committed by the Communist Party of the Philippines immediately, because that is the effect of what you're saying. Is that not correct?
No, Your Honor. Because the information clearly states that they were committed by CPP NPA leaders, Your Honor.
By the CPP NPA leaders?
Yes, Your Honor.
Yes. So therefore, we cross that factual antecedent. You are now accepting that they may be the act of the CPP NPA for purposes of having your client now released.
Yes, Your Honor, for purposes of this habeas corpus petition, Your Honor,
Okay,
and for
now-
it to be absorbed in the Hernandez Doctrine.
Now, what we need to determine is whether the CPP NPA committed these murders in furtherance of rebellion. Is that not correct?
Yes, Your Honor. The resolution itself states, Your Honor, the acts...
And you want the Supreme Court, in fact, this third division, to hear the facts of that case.
It need not hear the facts of the case, Your Honor. All it has to do, similar to a motion for...
But again, I ask you, were these soldiers? Were these spies?
I
Or
don't
were
know,
these
Your Honor.
ordinary civilians?
My basis only, Your Honor, is the resolution
So how do
finding
we
of the
know
government, Your
whether
Honor.
they were killed in the act of rebellion or whether or not they were hogtied? They were one of the 100. That was the project of the Operation Venereal Disease. Colleagues, collaborators, kasama, who were hogtied, who were imprisoned, who were detained, and then shot summarily. We do not know that. Is that not correct, Counsel?
We only have to base it on the face of the information and resolution, Your Honor. It is on that basis that we come
On
to
the
this
basis
court.
of the information, therefore, when people are hogtied and shot, that is included in the act of rebellion.
No, Your Honor, because in this case there is a specific allegation, Your Honor.
Because of Common Article 3 of the Geneva Conventions, as well as Republic Act 9851, even a legitimate insurgent force, whether Protocol 1, armed conflict of an international character, a belligerent force, or Protocol 2, armed conflict of a non-international character, an insurgent force, all are supposed to be guided by the laws of war. Is that not correct?
Yes, Your Honor, but
As a matter of fact,
9851 came into effect only after 1985, Your Honor.
Yes, but you did admit that Common Article 3 is jus cogens since 1949.
Yes, Your Honor, but there was no basis for penal action at the time this offense was committed, Your Honor. It would fall under People versus
the penal
Hernandez.
action is murder. Is that not correct?
Yes, Your Honor, but if murder is committed
And
in furtherance of rebellion,
1991, within the acceptable period, which is 1985 to 1992. In 1991, I do not know if you do know that there was a declaration of adherence to international humanitarian law issued by the National Democratic Front. Would you know?
it was
Counsel?
part of your concurring opinion, Your Honor.
Yes.
I read it there.
And also in the NDF, again reiterated the Declaration of Understanding to apply the Geneva Conventions of 1949 and Protocol 1 of 1977. Is that not correct?
I read it in your opinion, Your Honor.
And of course, without reading it in my opinion, you know that the peace talks have a comprehensive agreement on respect for human rights and international humanitarian law signed by the CPP-NPA. Is that not correct?
I read it in your opinion, Your Honor.
Yes. So, therefore, if the CPP-NPA, which for putative purposes, for this habeas corpus, you are admitting that it may be part of the organization of the detainee, if the CPP-NPA already accepts that there are certain acts of war which cannot be considered as a legitimate rebellious act, then therefore, it is legitimate for this court to ask the trial court to hear whether these cases are indeed did occur, was there liability on the part of the accused, and of course, more importantly, are these politically motivated, which is a matter of defense by the regional trial court. Is that not correct?
I would like to disagree, Your Honor.
Yes. Okay, now, supposing we deny the writ of habeas corpus, we deny the final remedy of habeas corpus, we did issue the writ of habeas corpus, we deny the final remedy, which is, or we deny the petition, which is to ask for the liberty of the accused with or without conditions. Do you still have remedies?
Well, the remedy would be go to the trial court, Your Honor,
Yes. And
while our client is detained.
had you gone to the trial court before filing the writ of habeas corpus, you would not have wasted time. Is that not correct?
Pardon, Your Honor?
Had you gone directly to the trial court and immediately raised double jeopardy, now you would be hearing the affirmative, you would have a summary hearing to determine whether or not, in fact, there is double jeopardy. Is that not correct?
Yes, Your Honor, but the
Yes.
period by which that hearing, including presentation of evidence, will take, nobody knows, Your Honor.
Yeah, but it can also happen if we deny the petition.
Oh, yes, Your Honor, yes.
Yes. And by going to the Supreme Court with the assurance that the Supreme Court will hear both sides, there is no luck that we will grant the petition for the writ of habeas corpus.
Yes, Your Honor.
Yes, and therefore, it is not the burden of this court to delay the proceedings further by either maybe deciding the case, issuing a temporary restraining order, and in the end, perhaps even dismissing the petition. Is that not correct?
That is one of its options, Your Honor.
Yes.
But here,
Especially if the court is seized of certain information, like certain doctrines, that it will have to follow. Because as you notice, we are a division of the Supreme Court. And divisions cannot alter or modify the existing doctrine unless we elevate the case to the court en banc. Is that not correct?
yes, Your Honor.
Yes. And therefore, there is a possibility that this court should immediately rule on the petition for habeas corpus so that you can, with dispatch, actually go to the regional trial court. Is that not correct?
I would like to believe that based on the issues, constitutional issues presented, that this court should uphold the double jeopardy issue of Rudy Salas.
Regional trial court, can it consider constitutional issues?
It can, Your Honor, but the ultimate judge of whether the regional trial court ruled correctly would still be here. That is why, as I mentioned earlier,
We
those
are,
cases where double jeopardy was raised before the lower trial court, they still found.
yes, may I cut you
It's way
there,
here.
counsel? We are the ultimate judge. We have finality. But the Supreme Court can be mistaken. Is that not correct?
Oh yes, Your Honor,
Yes.
nobody is infallible.
But if the Supreme Court is mistaken, there is no appeal. Is that not correct?
Yes, Your Honor.
If the regional trial court commits a mistake, there is an appeal, correct?
Yes, Your Honor.
So there is an advantage to going to the regional trial court. Is that not correct?
Not necessarily
And
considering
that
the
it can,
situation of my
the
client.
case regarding the factual antecedents, if there is any doubt on any part of the member of the third division, if they are not sufficiently convinced that the facts are as they are, then it is possible that the facts can be fully litigated in the regional trial court so that we have full information when we review the actions of the trial court.
That is a
not-
possibility, Your Honor.
That is a possibility. Now, can I ask you this question? Having been counsel for Flag and having been counsel for the accused, as you admitted in the act of rebellion, at the end of the war, there needs to be transitional justice. Is that not correct?
Yes, Your Honor.
Everybody has to account for all the acts that they have committed in order that there is a closing, of the books. Is that
Yes,
not
Your Honor.
correct?
In a sense,
Including forgiveness and remorse, if that is possible, and retribution and deterrence, if that is necessary. Is that not correct?
Yes, Your Honor.
At the end of the day, if there were mistakes that were committed by the movement, such as if the information is true, such as theoretically only, that there were 67 deaths and they were not properly disposed of, put in a mass grave, if that were true, then anyone who would have been involved in that particular case at the end of the war would have to account for it. Is that not correct?
Yes, Your Honor.
And it's part of the leadership of a movement that calls for violence, that they have to take that as part of their responsibility in order to be able to heal the country later
Yes, Your
on.
Honor.
Yes. And therefore, it is important that at some point, all these cases must be heard by a trial court. Is that not correct?
Not in this case, Your Honor.
Not in this case.
Or
because your-
specifically for Rudy Salas, Your Honor.
Yes,
Solely.
because your theory is that having found a mass grave where the bodies were put one on top of the other and left to fester without informing the relatives, okay? If that were an act of the CPP-NPA, it would have been part of the rebellion of the CPP-NPA. That's your statement.
Yes, Your Honor.
That is the kind of movement led by the leaders of the CPP-NPA.
I have no business in judging that movement, Your Honor. I am here only to say and apply the doctrine of this court in Amado Hernandez, Your Honor.
Yes, but in Hernandez it said for a political motive. And killing by itself, per se, is not political. You have to prove whether or not it's political. Ocampo.
Yes,
Correct?
Your Honor. But in the case of Rudy Salas, Your Honor, he has been convicted, and the presumption, therefore, for acts committed by that movement during that period is absorbed by his conviction.
Again, the position of your client is that the rebellion that they lead includes the act Inobatan,
Inokapan.
Inopakan, Leyte.
That is the allegation in the resolution and information, Your Honor.
But
And
you-
that is our basis to
That's your
say
basis.
that it is absorbed by the rebellion, Your Honor.
So in effect, you accept it but not.
I accept it, Your Honor, that the resolution itself says so. And therefore, the doctrine of Hernandez, by the conviction of Rudy Salas, includes that. I am not here to judge the morality, correctness of that act, of that movement, Your
Neither
Honor.
are we, because I think that we have to decide which acts are really included in the crime of rebellion, considering that in the Hernandez case, the question was whether we should complex it or it is absorbed.
Yes, Your Honor.
It
But
was
that is
not
yet-
seized with an issue as to whether rape was committed or as to whether the homicide was not related with a political motive. Is that not correct? Yes. So in this particular case, we are confronted with the statement of facts, where again, it is a mass grave. The bodies are put on top of each other. It had to be the army that discovered it. The relatives did not know, and I think due to forensics, they were able to identify whether that can be included in rebellion or whether we should give reasonable doubt and allow some kind of forum where the facts can be presented with evidence.
Your Honor, insofar as this case is concerned, a habeas corpus case for the charge for double jeopardy, this court can only go and look at the information and the resolution as basis, whether or
Precisely.
not those offenses are absorbed in rebellion.
Precisely, that is what I'm saying.
Yes, Your Honor.
Yes. So therefore, we have to look at whether those facts
In the
putatively
resolution.
are now included in the act of rebellion.
Yes, Your Honor.
Although in Ocampo we said, same case, in fact, the same docket number.
Yes, Your Honor.
We said that certiorari is not available because we need to know whether there was political motivation. Is that not correct?
Yes, Your Honor.
Okay. This case has been pending for quite some time. Is that not correct?
Yeah, the case in
The
the
case
lower...
in the lower court, right?
Yes, Your Honor. It
Yes.
has been there.
You were counsel in the rebellion case. Is that not
Yes,
correct?
Your Honor.
Did you file for plea bargaining in the murder case?
This case,
Yes.
Your Honor? No, Your Honor.
Did you move to dismiss?
No, Your Honor.
Why?
He was being detained illegally, Your Honor.
In
And
other
therefore he
words,
came up here.
there was an open case.
Pardon,
So
Your Honor?
there was an open case, this murder case.
Yes, Your Honor.
There was the rebellion case. In the rebellion case, there was plea bargaining, correct?
Yes, Your Honor.
You did not use that rebellion case to have this case dismissed.
Not before the lower court on the ground of double jeopardy, Your Honor.
And this was pending since 2006, correct?
Yes, Your Honor. He was only arrested recently, Your Honor.
In 2010.
Pardon, Your Honor?
In 2020, correct?
Yes, Your Honor.
So
Just
that was
a
a
month-
period of
a month
14
ago.
years, correct?
Pardon, Your Honor?
14 years.
Yes, Your Honor.
That there was a pending case, correct?
Yes, Your Honor.
And you knew that it was open case, correct?
Not that I know of. I only came to know about it lately, Your Honor.
But I remember my training under your organization, and that was to give complete service to clients and to try to complete the circle. Maybe what you should have done in order to finish this case was file something in the homicide case, correct?
Yes, Your Honor. But at that time, Your Honor, when Rudy Salas was convicted and later released, my obligation as a lawyer to him ended, Your Honor.
Okay.
It was only when he called me up a week before he was arrested that he said, meron pala akong warrant of arrest. Ano ba gagawin natin? That is the only time Flag took action, Your Honor, was to take action. And we were supposed to meet with him the next week. However, the day before we were supposed to meet with him, he was arrested.
Okay.
And that is why we are here before this honorable
What
court.
would have been the proper remedy had he not been arrested and had you known that there was a pending murder case?
Well, there are a lot of remedies, Your Honor.
For instance,
For instance, you would have filed a motion to quash, which again would result in the same problem because a warrant would have been issued.
a petition for habeas corpus, correct?
Since he was not yet arrested, no, Your Honor.
So a motion to quash would have been the proper remedy, correct?
But, Your Honor, he had to surrender.
Yes.
And therefore, he had to be detained.
Yes. And therefore,
and
still a
therefore-
motion to quash.
What? Pardon, Your Honor?
Still a motion to quash, correct?
A motion to quash, yes, Your Honor, because
Yes.
we filed it ahead.
And because you would surrender him, he would be under detention, but you filed a motion to quash.
Yes, Your Honor, but the detention now would take...
So it's also
Ano?
possible that even if you file the petition for habeas corpus now, he's under detention, you can also still file a motion to quash.
No, Your Honor.
You cannot file a motion to
We
quash?
can no longer file a motion to quash it
Really, why?
because it might deem a waiver of this action before this court, Your Honor.
No, I mean, if this case is dismissed, this petition for habeas corpus is dismissed on the ground of Section 4, Rule 102, People versus Hernandez, Ocampo, not even People versus Hernandez, but we can just state Ocampo. We are unsure whether Hernandez ruling still applies considering the factual circumstances. Can you file a motion to quash?
Yes, Your Honor, but that would again entail him being detained, and it would not be a viable, speedy, and adequate remedy.
Bail is not available?
Bail, Your Honor, is available, but for bail to
What
to
was
be
the charge in this case?
murder, Your Honor. For
Murder.
bail to be available, Your Honor, there would have to be a hearing, and
Yes.
it is that very jurisdiction of the
And
court.
the trial court here, I think you did manifest that there was a setting on March 17,
Yes, Your Honor.
and it's the whole day.
Pardon, Your Honor.
It's the whole day.
Yes, Your Honor.
The whole day.
Yes,
right?
Your Honor. I'm surprised
Isn't
why.
it a signal that you can file a petition for bail?
Not necessarily, Your
Not
Honor.
necessarily, but it's
Because-
up to you. It's your option.
The notice order of the court is for arraignment, Your Honor.
Yes. And it is possible that the judge wants to proceed through continuous trial with dispatch. Is that not correct?
Well, that is the order of the court in Ocampo. Ordered the lower court to proceed with dispatch in the case. But how
And,
long has it taken, Your Honor?
It is not for us to determine whether or not the court will delay or the court will not do its duty. Is that not correct?
Yes, Your Honor. But
We have
I
to
am
assume
basing
that
my
the-
opinion on past cases, Your Honor.
Yes, the RTC, you mean this particular judge?
I really don't know, Your Honor.
Yes.
I
The
haven't
past
done any-
cases that you mentioned regarding the delays in double jeopardy, was it this particular judge?
Pardon, Your Honor?
Was it this particular judge? You did mention a lot of cases in double jeopardy, with double jeopardy.
No, Your Honor. It was not this particular judge, Your Honor. It was cases
Okay.
decided by this
So,
court.
using
many
the
years
res inter alios acta rule, we cannot say that this judge will also delay. Is that not correct?
Not necessarily, Your Honor.
Not
But
necessarily.
I can always say that whoever loses in that case will find himself again up here. And so the ultimate issue of constitutionality will be here again.
But
We
is
will-
it possible that the regional trial court judge will look at the evidence and say that it's insufficient?
Pardon, Your Honor?
Is it possible that the RTC judge will find for the defense?
Yes, Your Honor.
Yes.
As
So-
it did as lower courts
Yes.
have found in other cases.
Is it
but
possible-
The prosecution brought it up here, Your Honor.
Is it possible with very competent and energetic and professional counsels such as yourselves that it is possible that you do all the remedies possible at the right time with in the right way, and the court will grant your petitions?
It is also possible that despite what we do, Your Honor, the court will not grant our petition. And
Yes.
if it grants our petition, the prosecution will certainly question it and we will come up here. Our client
But
will
that-
still be detained.
That did not answer my question, counsel. You avoided the question.
No, I'm not avoiding the question, Your Honor.
Yes.
Yes, we can, but it
Yes.
also can
Okay.
mean the other way around.
In other words, it's possible that the trial court can grant your reliefs.
Yes, Your Honor.
Yes, thank you. Finally, do you agree with this statement? The rebel, in his or her effort to assert a better view of humanity, cannot negate himself or herself. Torture and summary execution of enemies or allies are never acts of courage. They demean those who sacrificed and those who gave their lives so that others may live justly and enjoy the blessings of more meaningful freedoms. Torture and summary execution in any context are shameful, naked brutal acts of those who may have been transformed into desperate cowards. Those who may have suffered or may have died because of these acts deserve better than to be told that they did so in the hands of a rebel. Just a statement alone, no relation to your
I
client.
agree with you.
Thank you, counsel. One question from Justice Esmundo.
Just to be clarified, Mr. Counsel for Petitioner, is it your submission that the murder charges, 15 murder charges pending in the court, is absorbed in the case of rebellion where your client was previously convicted?
Yes, Your Honor.
In effect, you are admitting that there was a crime committed by your client, only that he cannot be prosecuted.
Pardon, Your Honor.
In effect, you are admitting that your client committed the 15 murders, okay, but he cannot be prosecuted anymore because of the provision in 2E. Is that correct?
Yes, Your Honor, based on the information that they are charging him for, Your Honor. They are accusing him of that.
Okay. Are you aware, obviously you're aware, that this may result in a situation, just giving a hypothetical situation, that your statement will be considered as an admission of guilt?
Your Honor, in a habeas corpus petition, in this argument in this court.
Yeah, but you are aware of the rules on evidence.
Yes, Your Honor,
Acts
I
or
am.
omissions made by a party may be given in evidence against him.
My basis of saying yes, Your Honor, is on the basis of the resolution and the information. The
Yeah, but-
resolution accuses him of that. And therefore, the habeas corpus petition is based on that resolution and the information and the act of double jeopardy.
But the pleading in a petition for habeas corpus would constitute a judicial admission.
Yes, Your Honor. Here, Your Honor, we are admitting that there is an information. That information charges my client for acts committed as leader of the CPP, NPA, NDF.
Correct.
That information is based on resolution having factual findings.
Yes.
Those factual findings say that my client and others committed these 15 killings. My position is taking that by itself, without whether it is true or not, it is absorbed by his previous conviction. Why? Because that information and resolution charges him as a leader for which he has already been previously charged.
So are you saying that this is not in the nature of a judicial admission?
No, Your Honor. It is, I am looking only at the information and resolution. On that basis alone, am I saying that that is the charge, let us take it on its face, and if it is true, it should fall under rebellion.
I thought earlier you were saying that this is in the nature of an immunity from prosecution already.
Yes, Your Honor, based on double jeopardy.
Thank you very much.
I just missed one set of questions. Echanis was released on bail for 100,000 for the purpose of participating in the peace process. Is that not correct?
That is the ruling of the court, Your Honor.
In Ocampo.
Yes, Your Honor.
And in the case of Ocampo, Satur Ocampo, would you have any document to show the reason for the release on bail? Perhaps you can submit that to the court today.
Your Honor, I have no connections with Ocampo, but I just read the decision earlier.
No, the
and it just
decision-
says there in the dispositive portion that, can I read it, Your Honor?
Yes. No, but the dispositive does say,
Dispositive portion states, wherefore the instant consolidated petitions are dismissed, the RTC of Manila Branch 32 is hereby ordered to proceed with dispatch with the hearing of criminal case so and so. Petitioner Saturnino C. Ocampo shall remain on temporary liberty under the same day granted by this court until the termination of the proceedings before RTC Manila.
okay,
That is for him. The others, Your Honor, are conditioned, as you said.
conditioned on the
Continuing
peace
peace
process.
negotiations. Yes, Your Honor.
Is the detainee, because I understand your client is the son?
Of course, automatically, Your Honor, it includes the detainee.
Okay. Your client is he participating in the current peace process?
No, Your Honor, he has not been participating in any of these peace processes.
Not participating in any of the peace processes. Okay, thank you. Okay, these are the instructions to the parties. Please take your seat. The parties are ordered, since this is a habeas corpus proceeding, given a non-extendable period of 5 days, within which to submit their entire memoranda to the court, with personal service to the court and to the other counsels, in order that we can immediately and rule upon this with dispatch. I understand that there is we understand and we take note that there is a March 17 setting in the regional trial court. I think it is understood that if we issue a TRO, then that is suspended. If we do not issue a TRO, that means that likewise is an action of the division. Nonetheless, again, due to the nature of this case, a non-extendable period of 5 days, following the usual format of memoranda submitted to the Supreme Court. After the submission of the simultaneous memoranda, there will be no rejoinders that will be accepted by the court. Thereafter, the case is submitted for decision by the third division. There are other cases, clerk of court, to decide as of the moment.
Your Honor, none, Your Honor.
There being none, the session is now adjourned.